take one. Sort of this क्या होता है? बच्चे कहीं कोई डायरी उठा लेते ना? जरा कहीं कोई डायरी उठा ले बताओ। पेमेंट की, नेट बैंकिंग की। मालूम नहीं जाओ मम्मा को। ऊपर ड्रॉयर में, नीचे नीचे फैला में रहेगा।
नॉर्मल ड्रॉयर में,
नॉर्मल ड्रॉयर में नीचे के हिस्से में रखो रहेगा देखो। सीधा हो। एक परस की पार्टी। पैसा अगर बोला था पैसा
Because of property, mentioned in favor of petitioner.
Hmm.
Coming up on they have knocked us out of the property and they come that we can't pay the license. 2 days ago, we have paid 21 lakhs. 2 days ago, we paid 21 lakhs.
Any balance?
This about, it's nominal about 5 lakhs and we undertake to.
So Monday get a demand also. Monday?
Monday there is a wedding ceremony.
2:30. So who is appearing in Monday? Fresh matter or?
So the.
Karan, Sharath Goda, either of them. Iballa? Goda. Any convenient date on January. Third next week. ಏನಪ್ಪ BBMP ಎಲ್ಲ BBMP ನೇ ಇಲ್ಲ ಏನದು what do you want you for mentioning is when juniors get a opportunity to make submission, so you should use this opportunity in invest ಬಿಡಲ್ಲ ನಂಗೆ ಹೇಳಿ ಗೊತ್ತಿಲ್ವಾ ಎಲ್ಲದಕ್ಕೂ ಫಸ್ಟ್ ಟೈಮ್ ಇರುತ್ತೆ. These are the opportunities you have to use. Ground rent. Use this mentioning opportunities. Always new time figure. Opportunity figure. Monday. Ground rent not here. Yes. Therefore,
for any disposal, because they have been put because these are important. Very convenient.
next week I'll more detail. ಏನೇನು ಹಾಕಿದ್ರೆ ಬರತ್ತೆ ಐಯಲ್ಲಿ ಬರತ್ತೆ ಇವಾಗ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಅರ್ಜೆಂಟ್ ಬಂದ್ಬಿಡು ಎಲ್ಲ ಪ್ರೊಸೆಸ್ ಅಲ್ಲ ಎಸ್ We'll finish this and the same order will be applied to that. 2017 matter. Watch. 2019 only agenda. 2019 or care about.
Number 10, serial number 46 to 61.
Yes. Go through it by afternoon and make yourself. 2018 matter. I mean, it's the order which you have to go through. It will be only 5 minutes. It is. We'll pass it out in the afternoon. 2018 we will. No. Yes.
My lord, serial number 47.
47, yes.
Senior sister expire ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ನೀವು ಯಾರಿಗೆ
ಪಿಟಿಷನರ್ ಮೇಲೆ
ಪಿಟಿಷನರ್ ಬಾಕಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ ಸರ್.
It's submitted that the bereavement in the family of the arguing counsel. The short adjournment is short for released on 13th December.
Okay.
Number 13, serial number 57.
Hello? 58. Yes. on 21. Have you informed the respondents? Why do you want time? Yeah. Accepting the reasons stated in support of IA 1 of 23, the production of certified copy of Annexure A is dispensed subject to any serious objection raised by the respondents. The written counsel for the petitioner seeks for and is granted. For accommodation, we list on 13th December. What earlier granted is extended to next month.
Case number 14, serial number 68. Case number 15, serial number 69 to 72.
Have you informed the respondents? Everyone at the request of counsel for the petitioner released on 18th December.
Case number 16, serial number 70, 79.
Unity. Have you informed petitioner inform ಮಾಡಿದ್ದೀರಾ? The counsel for respond number 1 and 2 seeks for and is granted 2 weeks time to obtain instruction and make a submission. We list on 18th December. Like. Have you informed the respondent? Counsel for the petitioner 19th December.
Yes. Number 74.
74.
Respondent number 5 millions. Need to file objections in this matter.
Inform ಮಾಡಿದ್ದೀರಾ?
Inform ಮಾಡ್ತೀನಿ.
Will ಬೇಡ. Inform ಮಾಡಿದ್ರೆ ಮಾತ್ರ.
Case number 17, serial number 80 to 85.
80? Yes. Have you informed everybody? Then please. Shall illapa, only if you inform mention. Otherwise we won't take it. Police station. Have you informed the? You are in the second matter. When do you want it? This is pending for some time. Objections are filed, Mr. Kumar? 23, at the request of counsel for respond number 1 to 3. 4 and 5. Indian role will allow 1 to 3. Mainly 1 to 3 has to. List on December. Interim order earlier granted is extended. 65. Yes. Have you informed the respondents? He's not for the respondent in 65. It's BC Sridham Reddy.
Case number 19, serial number 84 to 98.
Respond number 3 ilve illalla paile. 95. CM. 95. Shri T.A. Abdullah is directed to accept notice for respond number 2. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures on the said counsel. Objections, if any. Objections, if any, to be filed on or before the 3rd January, released on 10th January. Interim order earlier granted is extended till Wednesday.
Case number 20, serial number 99 to 100.
18. 18, wait.
but 29.
Wait, man. Bakery, we disposed that bakery matter, Kurmanga. Monday. Seven December. And appears for the petitioner, office objections have not been applied with.
Not serial number, is this serial number 2 minutes?
One.
Please.
9 office objection during the course of the year. Counsel for the petitioner 6 point is granted 3 days time. Not the first time. 6 point. Now the offense under 138. 138 number then. Where is the respondent? Where the respondent compromise on it? Compromise on ಅವರು ಹೇಳ್ಬೇಕಪ್ಪ ನೀವು ಒಬ್ಬರೇ ಅಲ್ಲ ಹೇಳೋದು ಕರ್ಕೊಂಡು ಬನ್ನಿ ಆಚೆ.
Serial number 2 minutes. Minutes, I am for the petition minutes. I'll withdraw the petition minutes. I'll file the memo in the counter minutes by the course of the day minutes.
That counsel for the petitioner
Petition minutes.
who appears through video conference seeks permission to withdraw the above petition. He submitted a suitable memo to be filed during the course of the day in the registry.
Yes,
By accepting his submission, petition is dismissed as withdrawn.
File it.
Yes. In office objection. Respond number 2 at 20 had expired prior to the filing. So file that application. That counsel for the petitioner submits that suitable application and order 1 rule 10 would be filed to implead the legal heirs of deceased respond number 20B and 20C. Since they had expired even before the filing of the above petition. Granted 2 weeks time to do needful, IA 2 and 2 to 4 of 2023, therefore stand dismissed. ಯಾವತ್ತೇ ಮಾಡೋಣ ಇವತ್ತೆ ಯಾವ್ದು ಕೊಡ್ತೀರಾ ಯಾವ್ದು ಆಗ್ತದೆ ಅಪ್ಲಿಕೇಶನ್ released on 18th.
My lord, in serial number 4,
Yes.
the counsel for the petitioner prays for a week's time, my lord. Serial number 4.
That counsel for the petitioner seeks for and is granted 2 weeks time to produce to make payment of necessary process fee and furnish copies. If needful
Please, my lord,
is
she is
done-
out of station. So,
If needful is done, registry is directed to issue notice to
Please.
unserved respondent returned by January end. 29 January.
much obliged.
Who is R3? Process fee. 6 fund is granted a week's time to make payment of process fee and furnish copy needful done. Issue notice 29 January. This file is application matter. Registry has not printed the name of the counsel for the impeding application. Registry is directed to do needful and released on 11 December. Yes. Want to take out and summons, you take out and summons. How many weeks? How many weeks you want? Counsel for the petitioner seeks for and is granted 2 weeks time to furnish current and proper address of respondent number 4 and make payment of necessary process fee. If needful is done, registry is directed to issue notice to respondent number 4 returnable by February 1st week.
I am petitioner in both the cases.
Yes.
Yeah, the respondent's panchayat advocate was directed to produce the license. There is no such license. PDO only called me. PDO only called me. They are issuing the license.
Produce the license. ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ ಲೈಸೆನ್ಸ್ ಅಂತ ಇದೆ.
ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಹೊಸದಾಗಿ ಲೈಸೆನ್ಸ್ 3 ಜನರು ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟರು, ಇವತ್ತಿಬ್ಬರಿಗೆ ಕೊಡ್ತಾರೆ. PDO only called me and he told the entire amount is recovered. 2.5 ಲಕ್ಷ 3 ಲಕ್ಷ ಕೊಡೋದಿತ್ತು, ಬಟ್ ನೆಕ್ಸ್ಟ್ 1 ವರ್ಷಕ್ಕೆ 2 ಲಕ್ಷ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವತ್ತಿಬ್ಬರಿಗೆ ಇವತ್ತು ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Let them produce it, Mr. Bali.
Yes, ಆಗ್ಬೋದು ಸರ್, ಆಗ್ಬೋದು.
ಕೊಟ್ಮೇಲೆ ಮುಗೀತಲ್ಲ ಅದು.
ಹೌದು. ಅದನ್ನೇ ಹೇಳಿದ್ರು, ನಾನು ಇವತ್ತು ಲೈಸೆನ್ಸ್ ಕೊಡ್ತೀನಿ, 3 ಜನ ಲೈಸೆನ್ಸ್ ಹಾಕಿ ವಿಡ್ರಾ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ PDO ಅವರು. ಐ ವಿಲ್ ಡೂ ಇಟ್ ಬೈ ನೌ. Yes,
so withdraw ಮಾಡಂಗಿದ್ರೆ we'll record your submission,
ಲೈಸೆನ್ಸ್ ಬರ್ಲಿ ಸರ್, ಕೈಯಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಮಾಡ್ತೀನಿ. He only PDO only called. Yes, ma'am.
Request of both the councils released on 7th December.
ಆಗ್ಬೋದು ಸರ್.
By which date the license copies to be produced before this question.
Stay may be kindly extended till then.
What earlier granted is extended till next day.
Yes, ma'am. Much of.
Which for the impleading of it filed by petitioner. Yeah, now who do you want to implead? As co-petitioner or as respondent? You notice on IA 1 of 2023, returnable by January 18. Notice ಹೋಗಿ ಬರ್ಲಿ, ಅದು ಫೈಲ್ ಮಾಡಿ ರಿಜಿಸ್ಟ್ರೇಷನ್.
including phone.
Despite order date 7/11/2023, none appears to the petition today also. Compliance has also not been made. It appears that the petitioner is not interested in prosecuting the matter for petition. Counsel for the petitioner seeks for and is granted 2 weeks time to comply with the office of petition released on 8 December. Yes. Demolition or right. Where's Mr. Anja Reddy? Also for the petitioner seeks for a week's time to make payment of necessary process fee. Counsel for respondent number 1 and 2. 6 fund is granted a week's time to make a submission on the action taken. It is on 11th December. 13. Page
20.
Yes.
Complaint as a parties.
Forget about it. We agree, but they are parties to that proceedings. We don't know what they will say. They may not be agreed, but you'll have to make them a party. We don't know. ನೀವು ಹೇಳಿದ್ರೆ agreed or not agreed ಹೆಂಗ್ ಹೇಳಕ್ಕಾಗತ್ತೆ? ಆಯ್ತು, but they were parties to that proceeding. You'll have to make them party. They may choose to appear or not appear. They may not appear. It's their choice. But you have no choice. You'll have to make them parties. Pick and choose. Your party ಮಾಡ್ತೀನಿ, ಅವ್ರು agreed ಇಲ್ಲ ಅಂತ. You can't say that. Party ಮಾಡ್ತಿರೋ ಇಲ್ವೋ? ಯಾವಾಗ ಆಗ್ತಿರೋ application? Counsel for the petitioner seeks for and is granted 2 weeks' time to file necessary impleading application to comply with the office objection. Released on 11th December. On 3rd December. Yes. Yes, madam. Reading. Unity ಬಹಳದಿಂದ delay ಆಗ್ತಾ ಇದೆ. You filed for you only filed for the panchayat. Rural development ಆಗಿದೆ. List ಇಲ್ಲ. So I will.
Of appointment of nodal officers, district nodal officers, state nodal officers.
Yes.
Even with regard to advocates, appeal to RDPR, we have already formulated. Further appointment of officers.
ಅದು ಯಾವಾಗ?
They have addressed the letter even that. AG is that I ensured that the letter.
All CMCs are not. CMCs, TMCs, many of them are not being.
RDPR, we did the entire list. Here the first phase is getting the first. But the actual appointments is pending. So I.
ಯಾವಾಗ ಆಗತ್ತೆ Mr. Bean?
Previously, by not, she expressed reservation on the same. Yesterday to the AG, we have just communicated.
Simple question.
Second week of December.
So that we'll post it on that date so you can file it. That AGA submits that the Urban Development Department has commenced the process of appointment of nodal officers at the state level, district level, and taluka level. The guidelines having been processed, having been finalized.
Finally, already.
Nodal officers appoint aita.
Appoint Adila. What will be done now will be formulated.
The guidelines having been formulated, the nodal officers will be appointed shortly. Insofar as the panel lawyers for the urban development authorities, the guidelines having been issued, the appointment would be made within 2 weeks from.
Appointments are there. What is the duty and the reporting nature of cases we have done? Typically, what would be the duty?
So panel advocates are there now.
If they are not already there, is there then?
Some of the panel advocates have been appointed. And where no such appointment has been made, within 2 weeks, the appointment would be made. 4 weeks, the appointment would be made. Yes. ಏನ್ ಕೊಡ್ಬೇಕು ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಹೇಳೋವರೆಗೂ ಇರ್ಲಿ ಹೇಳಕ್ ಮುಂಚೆ ನೀವು ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ವಾಟ್ ಯು ವಾಂಟ್ ಸಕ್ಸೆಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ ಮಾಡಿಲ್ವಾ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಎಲ್ಲಿದೆ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಎಲ್ಲಿ 23.
Actually, he is my brother. Other two properties are changed in the name of. Authorities actually not.
Under what law are you asking for succession certificate? And what law are you asking for it after a family tree has been produced? You're not waiting for succession certificate, you're waiting for something else. Necessary document ಕೊಡೋದಲ್ಲ ಅದು ಏನಕ್ಕೆ ಬೇಕು ಹೇಳಿ first. You are appearing for them. Which law requires a succession certificate to be given when a family tree attested by the Tahsildar has been given? If there is no family tree, you could insist on the family tree or succession. Unnecessarily, you are harassing people. You are an inclined, and the purpose is very clear. Why? Yeah. Before this court, checking for the petitioners are before this court. The petitioners belong to a Hindu undivided family of one late D. Narayana. The said D. Narayana and his wife Lakshmi Devi having expired. The petitioners herein are brother are two of their children. ಸರಿಯಾಗಿ ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ
Brother of the petitioners. Two properties in the brothers name, three properties are changed in their name.
Narayana 65. Lakshmi Devi  they're all brothers. ಸರಿಯಾಗಿ ಹೇಳಿ petitioners belong to a brother and sister. They had another brother by name Arun Kumar, who has expired. Subsequent to his expiry, the property was stood in the name of the said Arun Kumar was sought to be mutated in the name of the petitioners by producing a family tree attested by the Deputy Tahsildar. The said application came to be was kept pending by respondent number 2 on the ground that the succession certificate had not been produced. In that background, the petitioner is before this court seeking for the following reliefs. The petitioners and the said Arun Kumar, being siblings, are not in dispute. Family tree having been produced clearly indicates the relationship between the parties. Once the said relationship is indicated and there is no other person who could claim in respect of Shri Arun Kumar, It was for the respondent number 2 to process the application by receiving necessary indemnifications documents and not insist for succession certificates, and no such requirement is provided for under law. Of the matter, I pass the following order. The petition is allowed, a mandamus is issued directing the respondents, respondent number 2, to consider the application dated 29/2022, so at annexure G submitted by the petitioner without insisting on a succession certificate within a period of 30 days from the date of receipt of a copy of this order. Counsel for the petitioner is also permitted to furnish a printout of the uploaded copy of this order, which shall be acted upon by respondent number 2 without insisting on certificate of. If respondent number 2 has any doubt as regard the veracity of the order, the same could be verified by scanning the QR code on this order. Dilapidated. Yes. Hmm. The reasonable time yesterday. Affidavit. Chief Commissioner dated 23 BBMP dated 23/11/23 has been filed. The Chief Commissioner has in the said affidavit categorically stated that the earlier report which had been submitted is not a technical report, and a fresh technical study would be conducted and a report submitted to reasonable time. That counsel respondent seeks submit that if 2 weeks are granted, the report would be filed. 2 weeks. It is gone. 11th December.
Lord, serial number 16.
16.
Lord, serial number 16 appear for the petitioners, my lord.
Yes.
On the last date, the Honorable Court had called for a affidavit of the Chief Commissioner, my lord. Since prior to that, they had filed the compliance affidavit of the JDTP instead of the Chief Commissioner.
ನೀವು ಯಾರು? ಯಾರು ನಿಜವಾದ ಓನರ್ ಯಾರು? ನಿಜವಾದ ಓನರ್ ಯಾರು? Who is the real owner? Respondent number 4 and 5 are not the owners of the property, Mr. Sampath.
My lord, initially, as per our verification, they were said to be the owners. Now it appears they are the builder.
Where did you verify it from?
At the property, my lord, because I'm the neighbor. I'm the neighbor at the property. The information given to us was because there is no plan sanction also affixed on the property. Later, it was disclosed that there was no plan sanction. So I had no way of knowing who was the owner of the property, my lord. In the plan sanction on 12th that was issued, it appears there are 3 other names, but the R4 and 5 are the builders, my lord. In fact, even when they filed Wakalat and they appeared 2 dates back, my lord, they didn't raise this objection.
On what basis do you say that they are the builders?
My lord, that was the information given to us at the site, my lord.
You can't go by information like that, Mr. Sampath. You'll have to be based in this. Proceedings for demolition. They are serious proceedings.
Yes, my lord. now that the plan has the names, my lord, I will include them as parties, my lord.
You can't go by just somebody on the road telling you who is the owner. Then somebody will say you are the owner of that property. Will you make yourself a party?
Apologies, my lord.
Can't be like that.
The difficulty was the construction was already progressing, my lord, without the plan.
Whatever the difficulty is, there's a expectation that you will do the due diligence and find out who the response have to be.
I understand, my lord.
And because of your submission, we had issued a bailable warrant.
Now that in the letter they have disclosed that the owners are somebody else, my lord,
Now, because of your submission, a bailable warrant has been issued. So a false submission has been made by your clients to you. So what do we do with your clients on the basis of some information? They say something. So there's a categorical statement made that they are the owners. And so many allegations have been made against fourth and fifth respondent in your petition. That cannot be on the basis of information.
my lord, when they filed their wakalat also, they didn't disclose, my lord, that they are not the owners,
It's
but
not
they're
for
the
them,
builder.
it is for you. The due diligence is for you, for a petitioner. You cannot come with clean hands.
My lord, I may be permitted to replace them, my lord. My lord, the petitioner is also 90 years old, my lord, the first petitioner.
If somebody comes and says 95 years old and files a case against you, we should accept it.
My apologies, my lord, I
Don't
understand.
make those kind of submissions. He's 90 years old, you'll be given due respect for that and due consideration. But you are required to exercise due diligence. And first petitioner is 90 years old. Third petitioner is 31 years old. What prevented 31-year-old through due diligence? You are appearing for whom? Petition copy is still not been served.
I gave it to them, my lord. They've been served last date itself. I can give another copy, my lord.
Show the acknowledgement for having served. Pass over.
Please, my lord.
What happened to the report? ಕೊಡ್ಬೇಕಪ್ಪ ಎಲ್ಲರಿಗೂ. First sheet is as regard the petitioner. Second sheet is as regard the respondent.
This is the plan which has been obtained in 2003 to Patagiri company.
Yes. The owner name M. Sanjay ಯಾರದು? You are going to appear. That is where deviations are alleged. 100%. Thousand?
The plan issued by the Karnataka government.
Construction has happened prior to 2013.
Photograph of the- That's like, after the taking and it was an immediate by the commissioner against the. Local commissioner was directed to the party.
When was the construction done?
Plan is not finished. We are not able to after coming to this complaint.
Mr. Mohan Kumar, you are saying plan has been issued by the erstwhile CMC. And it came into your jurisdiction in 2007. Thereafter, you have not issued any plan. But the construction has been put up in 2020, 2021. The photographs that you yourself have produced indicates it's a new construction. It doesn't look like a construction of the year prior to 2007.
This is like has been carried with the agriculture.
Yeah.
There is an expiry which have been initiated by the. Zonal commissioner, to go through this thing. Initiate the proceeding.
If the construction was prior to 2013, they'll be entitled to Akrama Sakyam.
Zonal commissioner examine whether it is a building or.
So, ಯಾವಾಗ ಹೇಳ್ತೀರಾ? Then it counsel for respond number 1 and 2. File an affidavit of the Chief Commissioner BBMP. Where it's indicated that notice and disciplinary proceedings have been initiated against the appendix. Yeah. It said affidavit taken on record. Another memo has been filed by counsel for respond number 1 and 2 enclosing the plan, enclosing the inspection report. The measurements as also photographs. The M. Sanjay. Additional complaints have been made. The so and so. You have filed a pleading application. You have filed. Pleading application. A 1 of 23. And in filed to implead. Said Mr. Sanjay. Accepting has been served. So and so has entered appearance. Accepting the reasons stated therein. Take into consideration that so and so has no objection. The said application is allowed. Counsel for the petitioner to carry out necessary amendment and file amended first act. Counsel for the petition is also directed to furnish one set of petition along with annexures. And so on so. Sri Mohan Kumar, counsel for respond number 1 and 2 submits that the zonal commissioner is now going through the file to ascertain the action that is required to be taken. If required, further inspection of the property would be undertaken to assess when the construction has happened. This is according to the petitioner, the construction has happened in the year 2020, 2021. Released on 12th December. any further inspection to be carried out on 1st December 2023, commencing from 10:30 AM. Date to fix no dispute. Yes. Impeding application another. Who do you want to increase?
Yes. They will try to object to the IA number 2 or the IA number 1 is IA of may not have given the work active. I already did. IA number is there, but page number 9.
Number 9 of your petition.
IA.
IA.
That is has to pass the order from 30th September 2023. Where is the cost for
Mr. Shetty, you are referring to IA 1 of 23.
Yes.
IA 1 of 23, page 9 is para 8. IA 1 has been filed by Mr. Chandanath Ariga.
Then
IA number 2.
Lord has pleased to pass the order
Yes.
on date 13th September 2023.
Yes.
Where next page is converted. Paragraph number 4 early page number aware. The respondent shall not interfere with the early property act. Hearing. However, it is made clear that most of the want.
Yes.
So I want to stop. That very next page, what he has made a letter, it's one of the line, the next page. See, Rescom authority, saying that disconnect the electricity. This is the attitude of the respond number 9. Who is personally having taken the vendetta against me, against my lord, the empire, who is the petitioner. She has started on the concept of the human environment that is masala portal.
So now the power has been disconnected or not?
No, because I have placed luckily.
New year again. What number?
Very next day, my lord, he brought the police to my premises. Along with police and PD to disconnect. Other than my lord, same day I have the certificate copy of the order of this one of the court. To disconnect the of the factory. Because the response number 9 that was personally interested to propel the petition of the Lord.
Yes, we'll consider it.
Yes.
What is this impeding application?
That is
ಹೌದು ಅದಕ್ಕೆ we'll adjourn it
Yes.
because we won't take it up. But this impeding application, if it is to be allowed, we'll allow it today. Want to file a right counsel for petitioner. 6 point is granted. 6 time to file. 2 weeks and a 10th tax. 2 weeks time to file objections to IA 1 of 23. Yen of 14. Objections, if any, we filed on or before 11 December, released 11 December. Petitioner has raised objection on IA 2 of 23 that the copies have not been furnished on the respondents. The counsel for the respondents acknowledged receipt thereof. As such, of his objection does not survive for consideration. That there's already an order passed by this court in WP 20571 of 2023 permitting the petitioner to run the factory. Respondent shall not interfere with such running the factory so long as the petitioner does not, so long as the petitioner does not put up any further construction. Released on 14th December. In the meanwhile, objections, if any, to be filed by the respective counsels for the respondent. comprehensive.
Yeah, except for equal.
Mr. Srinivas, your file now.
Yes. My lord, this case, my lord, see the photos.
The petitioner property is more than 60 years old.
Yes, that is not. Five or 5.5 years which have come out. How the petitioner comes to the court in complaints of they file a suit and that suit is being compromised.
Whatever is there between them is between them. It is a violation of building plan sanction.
That suit is being compromised.
Italy, but
The illegal construction is not compromise.
ಹೌದೇನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ, ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? That's why we've been saying all these matters are coming up before us because there is some ego issue or dispute between neighbors, father, son, brother, sister. That is what was coming about, or society and association.
So be a part of the system. That is what my.
So long as it doesn't come before you or
Yes.
before us, we may not direct. But once it comes before us, whether they compromise or not, it doesn't matter.
Saying about 8.5 years, which is come out of the ground floor itself, the neighbor comes to know that it has been deviated.
You are saying they come to know what you've been doing. You are the authority. You should have stopped this construction at that particular point of time, not resulting in this petition. You'll have to pass detailed orders on that. But look at you, your offices don't do, people have constructed till 5 floors. They did not have to construct. The large scale violation. Setback, height, everything. It can never be constructed without fire clearance. Nale on fire adre alli 5th floor, no fire brigade can reach. There are societal problems which are practical. Whether they compromise or not is immaterial. They cannot compromise the illegality. Let them compromise. What are you going to do now?
They issued notices, my lord, I have submitted notices.
248(1)(2) ಆಗಿದೆಯಾ?
Just verify. See. Not saying they 19th February 2021, representation complaint is not. Legal notice is given to the respondents.
You did compromise in the suit?
Suit was compromised in 2021. Construction is undertaken thereafter, in 2022. Sanction plan to build one floor, they construct 5 floors. They put up. Based on the automatic, you have to think as a they put up construction. The total floor is put up in that manner. Take about 42. They cover the entire building.
On their compound wall. You understand you want to help by not like this. Legally we can't understand, humanly we can understand. But ನೀವು ಇಂಥ violation ಮಾಡಿದ್ರೆ nobody can save you. You want to build wall to inch. What happened? Stations are to notice now. Now we are not deciding the matter. It is basically the inspection report which indicates. that counsel for respond number 327 has filed the inspection report. The same is taken on record. In the inspection report, it is categorically stated that such is not in accordance with the sanction plan. The FAR setback and height have been violated. Person is there to work has been stopped. The BS Srinivas, the counsel for respond number 327 submits that notices under section 248 are being issued to respond number 1 and 2. He seeks for and is granted 10 days time to place the same on record. We list on 14 December. Along with this inspection report only, you should produce it. They then need to get adjourned. If you place 248, then they will direct them to reply. They need to be adjourned for that reason. If it's not earlier granted, is extended. If not earlier granted, is extended. A. 32. I'm saying you highlighted something. What is this for? What are you seeking? What are you seeking in this matter? And SCGP accepts notice for response. 3. Seems equal. Kumar Gowda is directed to accept notice for respond number 4. Counsel petitioner. Yeah. Next one. 14th December. That would happen. Next. In the middle of the yes. You can argue on the main instruction. There was no road in existence. No road in existence in any revenue records, no acquisition made. I would worry Monday, Tuesday, and Friday. Then both of you want to place it. We'll have it on Tuesday. Serve it on the others. We'll have it on Tuesday. So that you, for whatever you want to file, you file. Serve it on them. Whatever you want to file, you file. ಒಟ್ಟುಬಿಡಿ ಇಲ್ಲಾದ್ರೆ ನನ್ನ ಹತ್ರ ಇವಾಗಿಲ್ಲ ಅಂತ. We'll have it on 28. You will have to, whether road physically is one part of it. Road legally is another part. Layout is sanctioned by? Layout is sanctioned? Face it, we'll take it up on Tuesday and take it up. The SP Shankar and Senior Counsel seeks for 3 days time to place certain judgments and documents, additional documents on record. Both the councils are directed to submit whatever document they respectively want to rely upon after serving the same on each other. Released on 28th December, it is made clear that no further adjournment would be granted. No further adjournment would be granted on that date. Interim order earlier granted is extended till next day. 28th, Tuesday. Yes. Yes. Sanjay Shetty.
Yes, my lord. I've got in touch with the PDO. He has inspected the premises. Some time may be granted. We'll file it, my lord. 2 weeks time is. He has inspected. He's
inspection as well. 2 weeks and
he's not well since yesterday. Is the PDO is apparently not well. It seems so. Some time may be granted. I will file it, my lord.
At council for respond number 2 to 4 submit that the inspection has been carried out. Since the PDO is unwell, the report could not be filed. He seeks for and is granted 2 weeks time to file the report. Released on 13th December.
Great.
Report to be filed before that date after serving copy on the council for the petitioner.
Grateful.
Yes. Outward register really. Register ಕೊಡಿ ಅಷ್ಟೇ. We have to see whether to quash it or not. 310 it was ordered to be adjourned to 1310. Now the notice was posted on 1610. After that date, it was received by them on 1710. 1310 to 1810 and orders passed. What to do with this order? This order has to go. Yes, Aku. Basic requirement is that before orders are passed, to see whether they've been served or not. Ashte. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that by notice dated 3/10/2023 at Annexure E, petitioner had been informed that the matter had been adjourned to 13/10/23. However, the said notice was received by the petitioner only on 17/10/2023 on account of the notice having been posted on 16/10/2023. From 13/10/23, the matter had been adjourned. On 13/10/2023, noticing that the petitioner is not there. On 13/10, ಏನು noticing illa. What do we say for that? From 13/10/23, the matter was adjourned, and on 18/10/2023, the matter came to be dismissed. In view thereof, the AG was directed to secure and produce the outward register. It is now submitted that the notice was indeed posted on 16/10/23, and there was no acknowledgement of service available on the record when the order dated, when the matter was adjourned on 13/10/23 and order was passed on 18/10/23. If that be so, then the impugned order at 18/10/23 has been passed without adequate notice to the petitioner, and as such would be required to be quashed. The respondent yaar passment is ordered. The note has to be put up. Has to be put up. Respondent number 1 to issue necessary instructions to his postmortem and future note. Respondent number 1 is directed to issue necessary instruction to categorically state, put up a note in the order sheet, categorically stating when the notice had been dispatched and when the notice had been served, so as to enable respondent number 1 to proceed thereafter on verification that the notice has indeed been served. In that view of the matter, I pass the following order. Writ petition is allowed. The order dated 18/10/23 passed by respondent number 1 in appeal number so and so at Annexure A is hereby quashed. The matter is remitted to respondent number 1. The petitioner and respondent number 4 to 6 shall appear before the first respondent number 1 on 7th December 2023 at 3 p.m. without requirement of any further notice. So the matter is slated for arguments. The pleadings have been completed. Arguments should be heard on that day and orders passed in accordance with law. What are you then?
Here for the section. Page number 18,
18.
18.
86.
Not a part, the order of the honorable court. By the virtue of this measure, the municipality has been directed to consider our deviation. Regarding the deviation as well as the user of the property. It doesn't have a preamble. That's how it has been passed.
That council office has raised an objection as regards the order dated 27/6/2023. Annexure M that the same does not consist of a preamble and all the details of the parties. That counsel for the petitioner submit that Annexure M is as received by the petitioner. Accepting the said submission, office objection is overruled. However, it will be for respond number. Let's say respond number 5 to explain the lack of preamble in Annexure M as and when they appear. That AGA accepts notice for respond number 1, 2, 6, 7, 8. Shri Gururaj Joshi is directed to accept notice for respond number 3. The A. Ravi Shankar accepts notice for respond number 4. 4 and 5. 4 and 5. What is A. Ravi Shankar? 5? Vidya S. Chief Pinapay. Vidya S. is directed to accept notice for respond number 5. Issue notice to respond number 9, returnable by 19. Immediate notice returnable by 19th December. What is it?
That he was not to the property to any commercial reason. Now it was based on that undertaking without any taking further action. Though the deviation was noted at 100%, saying that it could be regularized under money from the subject to the orders of the government. Such proceedings were terminated. Notwithstanding the said undertaking given before the municipality continues to
Where is undertaking?
This patient for 81 months, unnumbered paragraph in the speech. Make and obstacle fact. Make and obstacle for the constitution that the over against the party. Adhikaram and the Karnataka Municipality Act. HOD and the caste segregation and section 28 that is present the party of maybe the section of executive that section must be a I regard to be a Adhikara Adesha entire to be a second of the translation of
in a residential area. Respond number 9 is restrained from using the premises for any purpose till the next date of hearing. The AGA is directed to place on record if the application for regularization has been accepted, if so, on what grounds. Please also. Process fee and copies to be furnished by end of day tomorrow, failing with the interim order will stand automatically vacated. Large copy of Annexure B, in Annexure B and
Annexure B is not the plan.
yes, what is the petition about? Unauthorized, illegal, deviated construction. But you will have to produce this. This is whose plan is this? Respondent's plan. Yes.
number 27.
Hmm.
Yeah, I approached this about complaining about the intelligence.
Hmm.
This is about Malad. I created a paragraph.
Provisional order had been passed.
Because the directed response to approach the commissioner in this regard.
Has a confirmatory order been passed? Very
And
fine.
KT has confirmed the order passed by the respondent.
Yes,
This is the condition A.
yes.
And they have also directed the respondent of 1 to 3 to take
K is not K, it is chief committee.
because
Yes,
and this is the page number 38 between this.
yes. This is not, is it a subject matter of an appeal?
Yes, ma'am.
Appeal ಹಾಕಿದಾರ
Appeal.
ಇದ್ರ ಮೇಲೆ appeal ಹಾಕಿದಾರ?
ಇದರ
No appeal has been filed. What to do with BBMP? You don't value your own order, what to do? The chief commissioner has dismissed the appeal, even then construction is going on. There is no value that BBMP gives to its own chief commissioner's order. So if your officers cannot value the chief commissioner's order, why? Each photograph gives a different stage. Absolutely no setback. Pawan Kumar accepts notice for respondent number 1 to 3, issue emergent notice to respondent number 4 and 5, returnable by 18th December. The contention of the Warrant Council petitioner is despite the appeal under section 250 being dismissed, despite the appeal filed by respondent number 4 and 5 under section 153 of the BBMP Act 2020 being dismissed, respondent number 4 and 5 are still continuing with the construction. Once a confirmatory order under subsection 3 of section 248 is passed, it would be essential and imperative for the officials of the court that there is no further construction resulting in further violation committed by the person against whom a confirmatory order has been passed. In the present case, it is rather shocking that even after the chief commissioner has passed an order dismissing the appeal, the officers of the corporation are not taking any action. That would only amount to the officers of the corporation not having any regard for the implementation of the order of the chief commissioner. Commissioner is direct look into the matter. Directions to all his officers. Since it is on account of non-compliance by the officers of the corporation that these before. Since apparently the officers of the corporation have not been able to restrain construction by respondent number 4 and 5, the jurisdictional police officers, the jurisdictional police inspector is directed to ensure that there is no further construction carried out by respondent number 4 and 5. That in the name of learned AGA, so as to enable reporting of compliance. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the learned AGA by end of day today. Process fee also to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated. Bit of the chief commissioner to be filed, indicating what steps the office of the corporation are to take post the confirmatory order under subsection of section 248 as also post the appeal filed under section 253. It is done so. Challenges. 152.11B. Apply to the lessee also. 152. The owner and lessee, lessee cannot be treated differently. Don Kumar accepts notice for respond number 1 to 3. Counsel for the petitioner is granted 2 days time to comply with the office objection. The demand made by the respond number. Page. By the respondents at annexure G, he stated till the next date of hearing, since even a lessee would be entitled to the benefit of section 152(1)B of the BBMP Act 2020, so long as the petitioner is carrying on charitable education activities in a charitable manner. Released on 14th December. Yes. Videshwara. To that 14, 15, 16. Then Mr. Raghavan argued that matter. It is shown in the RMP, no? Disnala. The question Bharata line. That he has pointed out that judgment. See, if there's a rational way, you should include it in the RMP now. There's a decision like that, and you are aware of that decision of the year 2012 when. You include Martin and Renge.
Running water. Next photo ಅದರಲ್ಲಿ ಮಣ್ಣು ಬಿದ್ದಿದೆ, ಮಣ್ಣು ಬಿದ್ದು ಬ್ಲಾಕ್ ಆಗಿದೆ. ಅದ್ರ ಮುಂದೆ ಹೋದ್ರೆ ಐರನ್ ನಟ್ಸ್ ಎಲ್ಲ ಕಾಣ್ತಾ ಇದೆ ಸರ್. ಇಟ್ಸ್ ಇಂಡಿಕೇಟೆಡ್ ಬಿಕಾಸ್ ಇನ್ಪುಟ್ ಆಫ್
ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಅಷ್ಟೇ.
ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ನೆಕ್ಸ್ಟ್ ಫೋಟೋದಲ್ಲಿ.
This is
ಎಲ್ಲ ಫೋಟೋಸ್ ಡಿಸ್ಕ್ಲೋಸ್ ದಟ್ there was a under construction Rajkal.
stormwater drain.
Stormwater drain and subsequent years. Photo drain is not Rajkal is running property and the sketch is also disclosed that not.
Which is your property, survey number? 46.
Kindly request not to have next year B, which we have submitted along with the objection.
And there's no construction from 63 to 36.
Yeah.
Enu construction.
That is the report.
From 63 onwards.
Yes.
Yes.
Respectively, at lecture C, we have submitted the copy of the approved layout plan. We know where the respective sites are located. It includes site number
Annexure C, page number
7 of the section which we have filed today.
Yes. Who has sanctioned this?
This has been this is the panchayat which has issued this was part of this is just to indicate where the site is located. I will not rely on this for any other purpose. Respectively,
Then don't even point it out. You can't rely on it for anything.
and the report does not point out where the site is located. They point out where the nala is situated. The report entirely and the photographs, they don't show where the site is located.
Insofar as the nala is being done as per the map, and there exists a nala already, you cannot come in their way of making the nala.
I admit what they have submitted. For a moment, if I may be given
If this plan had been sanctioned by the BDA without showing the nala, then you would have been right. There is some panchayat who actually doesn't have any right to sanction.
I'm grateful for your consideration of what has been submitted by the BBMP, and in fact, I would want to rely on the same as
Yes.
well. Kindly have lecture B.
B. What is this?
This is the private survey which was undertaken a few months prior to the commencement of work in March, when I was forced to approach this honorable court.
Yes.
My lord will see this petition was filed way back in 2016, where I came and said, I don't know what they are doing. Essentially, at that time, there was just a marking on my property, which I came and complained about. At that time, from that time till now, there has been nothing put on record to show what work was actually carried out under what work order by the respondent. Subsequently, my lord, they have actually undertaken the digging work of the on the property, on the scheduled property, which my lord was pleased to observe on the date on which the honorable court directed stay of the further construction. With those photographs, my lord clearly noticed that there was a parallel nala running to the construction that was undertaken by respondent number 1.
That is on the left hand side.
Yes.
As the western side.
Yes.
Yes.
That is where essentially, in fact, further to the east, there should have been the nala should have been further into site number 10, as noted in annexure B. We very much admit what survey has been put on record, survey report has been put on record, insofar as the direction of the nala as per the village map. My lord will see the report itself, the map noting that clause 2, they specifically say there is no mention of the measurements of the nala. And as per scale, based on the village map, they have identified the nala. This is the report which has been placed before my lord.
Yes.
Report as well.
What is this survey that you are asking us to?
But this survey was undertaken for the purpose of identifying in relation to the village map where the actual nala is as per the Bhumi record, and where the nala subsequently has been dug up. And further, this was prior to when I made this application requesting this court to stop the construction this year, because this nala, which is now shown in 7, has been further pushed inside 7. There is one very important marker which my lord may be interested in arriving at a conclusion here. The village map may kindly be seen.
Who's carried out this survey? It's a private survey. It's a private surveyor who's carried.
Yes, of course. We would be very grateful if these details were to come out in the report of the ADLR, which was what we were hoping. There is no mention of what the boundaries of the scheduled property are. Of course, there is a mention of where nala runs. My lord, we can see the village map. Here in survey number 46, that is also annexed at annexure A. Survey number 46, there is a straight turn. Here, this is the lake. Just as we come down here, this is the nala. This is the property where the property of the petitioner is located. Yes. If my lord will see from the report filed before this honorable court, The survey sketch may kindly be taken, Mala. It is clearer here, 46. The same thing is denoted here. If my lord will see the survey report at Annexure B, which I find now, there is a marking of this as per the Bhumi records. My lord, if my lord will give me some time, I will be able to show the Bhumi records also reflect the same. However, these are Bhumi extracts. This also shows the same thing, my lord, where the Nala is running as per the sketch which has been submitted now. This is as per the GPS mapping. My site is away from this, and what has been actually put up has been marked in this private survey report which I am placing before this honorable court. And the construction of the Nala, concrete Nala, which they have now put up, is even further inside survey.
It is not as per the village map.
Exactly. The village map has been replicated in the survey, but the Nala's location in relation to the site has not been clarified to this honorable court, which is what led this honorable
So
court.
this page 10, what they have produced, they are not constructing it at that location is what you are.
Yes, sir. They had in fact pushed it further instead of going at the boundary of.
Not at that location, sir. Put further.
Exactly.
Yes,
Both the culverts in front of my property and behind my property have been shifted nearly 40 meters.
Annexure B, you will have to look at.
Private survey.
ಆಯ್ತು ನೀವು ಅಂತ ಸರ್ವೆ ಮಾಡ್ಕೊಡಿ. If you are construction of this nala is where the Raj Kalve is located in terms of the village map.
Once again, they will have to go and inspect.
The allegation is that yes, there is a nala. There is no problem about it. But you are constructing the concrete drain not where the nala is situated, but in a different location.
Including me, allegation, annexes and all report. The total visual is no is being carried out the corporation. Except where to tell the petitioner, there was existing Raj Kalva.
You are going to make that drain alva.
ಅಲ್ಲ, train ಮಾಡ್ತಾ ಇಲ್ಲ, ಅಲ್ಲಿ
ಇನ್ ಮಾಡಲ್ವಾ ಇನ್ಮೇಲೆ? ಇನ್ಮೇಲೆ ಮಾಡಲ್ವಾ ಡ್ರೈನ್? ಅದಕ್ಕೆ ಸೊ ಎಲ್ಲಿ ಮಾಡ್ತೀರಾ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು. Will you be doing it as per the village map or at the place that you want it? ಅದು RMP ಇದು ಬರುತ್ತೆ. ಅದು ಸದ್ಯಕ್ಕೆ ಇವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ, ನೀವು ಉಳ್ಕೊಂಡ್ರೆ ಅದು. ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ನಿಮಗೆ ಕಷ್ಟ ಆಗಿರೋದು.
Report is very clear. Report is very clear. Start first and second time some report check to the report.
He is not contesting the report. He is not contesting your report at all. Only thing he is saying is, if you come to page Annexure B, ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಈ ನಾಲ ಇರೋದು ಇದು ಗ್ರೇ ಪೋರ್ಷನ್ ಇದೆ ಅಲ್ಲ, ಆ ಗ್ರೇ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ನಾಲಾ ತರ 5 ಗುಂಟ ಅಂತ ಹಾಕಿದಾರಲ್ಲ.
I will supply.
Page 6, Annexure B. ದೊಡ್ಡಾಗಿದೆ. Site number 6 ಕಾಣಿಸುತ್ತಲ್ಲ ನಿಮಗೆ?
Even for movement not site number 6 and carry something that is not approved layout. It's not headed to
They're not an approved layout or not. Only for a marker. ಬೆಂಗಳೂರಿಂದ ಮೈಸೂರಿಗೆ ಇದು ರಾಮನಗರ ತೋರಿಸ್ತಾ ಇದೀವಿ ನಿಮ್ಗೆ. So their submission is that the nala flows through the so-called 11 and 6. We are not accepting the site number or the layout. Those location is there, but you have shifted it to site number 7 ಅಂತ ಅವರು.
Location divert ಮಾಡ್ಲಿಕ್ಕೆ ಯಾವ
You have no power. ಅದಕ್ಕೆ ಕೇಳಿ. That is what is allegation.
DC is only approved to divert it. But we are approved to remove whatever the report we made after Raj Kalva. Now we are doing it. Now written file and report has been separated from the by this government. Two the not months. What report is before this report?
Why did not you produce it earlier?
On the basis of this, it was already submitted.
You have produced it earlier.
On the basis of which my lord was pleased to direct.
Where have you alleged that instead of in the existing nala, they are building it in another place?
There was no nala, there was no water. I will submit Google photographs, here color photographs photograph which shows there was no existence of water flowing into the property anywhere in 46.
You have not made any such allegation in your petition.
Petition was very much before all this was taken up by the BNP.
You should have brought it to the notice. Then we could have asked them to make the submission. Now you are, after this, you are coming up with this.
My friend is objected that first day, sir. He might just put matter directly the second report has been secured by itself. Report is very clear.
Not my complaining note. My petition was complaining that I did not get any notice from them. The matter has now become the issue has now become what work is actually being carried out. Even now I don't have notice. Even now I haven't had an opportunity to understand what work is being undertaken and whether I should have an opportunity to challenge the same also.
This matter is from 2016.
You got this survey done in the year 2015, July to. From July 2015, you are sitting on this map.
My lord, 2016, I submitted saying there was, my lord,
Council behind 2023. Why was this not produced till now?
My lord, this was brought to my notice by the neighboring owner who has produced this in his proceedings. Site number 10 owner has approached for separately and he has sought for separate release before NGT as well. He brought this to my notice and said, this is not, respectfully, my lord, this is not something that was carried out for the purpose of filing of this proceeding. This was carried out to understand where they will actually be putting up the nala if they actually follow through with the construction of the drain after they dug up my property. My petition is very clear. I only saw lines of marking which I wanted to get addressed, which is why I approached this honorable court and requested the update about what they are actually trying to do in my property without notice. I will place on it, my lord, I have it next week. I will place Google Earth photograph to show there has been no light nala as late as last year also.
It doesn't matter if that's the thing. You produce this, it will have to go there. As per the village.
Fine, in this report, this survey is conducted in 15 or 16. There is no issue regarding the report, the survey is concerned with the petition.
He's only saying it has been done by a neighbor, not. But that doesn't take away that you will have to make it in where you have to make the concrete drain where the nala is located, not otherwise. Yav 11, your report. Yes. No, they have no objection on survey number 46. Our copy ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು? Actually, ಅವ್ರಿಗೆ explain ಮಾಡಿ. Have you given this copy to?
Yes, I have submitted.
You come to page 6 of this report.
We have 10 pages. Have the 11 pages.
And we furnished your.
Yes.
ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ? Given it to the SCG. ಅದಲ್ಲಪ್ಪ ಇವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದೆ have you given it to the SCGP?
I didn't notice that.
What do you mean you haven't noticed? The ADLR is being represented by the SCGP only. The first person that you have to give it is to the SCGP. We'll explain that to you. If you come to page 6. Annexure B. Only site numbers are only for reference. Site number 6 and 11 only. What they are saying is that as per the village map, it is located there. 46 only there. No dispute about 46. Their contention is that the nala is passing through in that location at site number 6 and 11 and not at 7 and 10. Their allegation is that the nala has been shifted while constructing the stormwater drain from its location. That is the distinction that now they are drawing. ಇದು ಮುಂಚೆ ಹೇಳ್ಬೇಕಾಗಿದೆ. You can't go by technicalities, Mr. Tulsi. You know, we don't go by it. If there the issue is there, we'll have to see.
I do agree with that. Is that because
But even otherwise, Mr. Council, Nala is there and you are accepting the Nala, then the buffer zone will bharat. It is what? Secondary Nala or?
Second, tertiary nala.
Illa
As I
pa.
pointed out,
It is connecting, it is secondary Nala.
yes, there are
Secondary Nala is 25 meters. You can't do anything in your side.
segment issues. After legal also, but I cannot advise that you have to go in the because respecting the law, I have documents from Google which I did not place on record because I was awaiting the response.
Insofar as the shifting is concerned, we can deal with it. But insofar as the usage of your property, you can't do anything with it.
I point out my God that there will be no line nala at all, no water flowing at all. Nala is matter apart. The work.
Unless it is extinguished in terms of section 67. Shows an order under 67. That you get it done. But counsel for the petitioner has filed objections to the ADLR report. The petitioner has very belatedly today placed a survey report of the year 2016, contending that the box drain which is now being constructed by the corporation is not at the location where not at the location marked in the revenue documents, but has been shifted. It was for the petitioner to have placed this before this court much earlier, since the survey report has been carried out, survey has been carried out in the year 2016. In view thereof, costs would have to be imposed on the petitioner. However, this court cannot, on that ground, deny the contention raised by the counsel for the petitioner, inasmuch as the report submitted by ADLR does not indicate as to whether the box drain is being constructed in the same location as where the Nala is located in terms of the revenue document. Counsel for the petitioner shall make payment of a sum of rupees.
Respectfully, my lord.
You have wasted a lot of time.
Senior counsel has submitted the entire.
Senior
set.
counsel agar inna jaasti.
I leave it to my lord.
Sum of rupees
There is
20.
no intention of avoiding this. This was,
You are sitting on it. You can't escape that.
and it is not my survey, my lord. I have relied on this based on what was handed over to me by a neighbor.
Shall make payment of sum of rupees 20,000 to the advocates clerks benevolent fund. The learned SCGP is directed to direct the ADLR to carry out one more survey indicating the Nala in terms of the revenue documents, as also the location where the box drain is now supposed to be constructed. The survey to be carried out commencing from 10:30 AM on 5th December. Report to be submitted by 15th December, released on 19th December.
For the report and the matter.
It will take some time to do it. You have taken 8 years to give us a copy. So they will take some time to do
May
it.
request that the matter be taken second week of that.
We are given our dates. We filed the application. We take, filed application to bring the legal representative on record.
This could be the legal. Put the respondent already, but he's not the legal. He's claiming that the put the respondent has adopted. That's 3 years. That's the age of 30.
You were given sufficient and long time to bring the legal representatives of See respond number 4 on record who expired on 8/4/2021. Have you filed any application?
Your white application crop on A. It's to appoint that. I mean, administrative general on any of the officer because after the death of the respondent and the schedule legals. It's
22/4 in. 60. Where's that application?
It's a year number.
But it's TPC.
One of 2020.
When was it filed? What has been passed on this?
Application is pending. Subsequently, when it's the leading up to spike the application to come on record as additional response. Please claiming this the legal data correspond number. Let's immediately after filing the memo, we have quite detailed application. Let's documents of the certificate. This one that let's
Now the trial court has considered him to be the legal heir.
That's the application. Do the appointment. Application. Subsequently, we have filed the application. After the death of respondent.
What has happened to those proceedings?
That application has to be considered.
What have you produced to show that?
That application we have not produced. Because we have filed the application before the trial court. That the mysterious petition.
Counsel, the basic requirement is when you plead something, you should produce some document in support. You have written 6 pages without producing any document.
We have produced document. That's that IA.
Where is the document?
IA 2 of the building.
IA?
It's additional documents we have filed.
A2.
Yes.
When was it filed? It's 7/20. Where is that? Show us that. Where is it? Yes, ಅದರಲ್ಲಿ ಎಲ್ಲಿದೆ ಅಂತ. We are not concerned with your affidavit. We are concerned with the document where she has stated it. ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. Your pleadings we will see. Show us that affidavit. Sure. One. Yes. Yes.
Next page back. It's a myself for myself. We have not adapted any.
This was filed when?
This appeared to be filed on 24/3/2018.
24/3/2018.
Reading the patent is concerned. It's contention that 31/2015, the deceased both respondent has adopted this person. Yeah, that is.
What has happened in that proceedings now? Where's the order sheet?
The application has to be considered with regard to weighted evidence. We say this because both respondents testified the application, so we thought the probate granted in the subsequently the rest was accepted. Yeah, but this simply is application not testified the application. We have filed the application that we mistake this itself is not maintainable because there is legal. But under such a case, we were concerned with the adoption of these concerns. There is a one the person at the age of 34 years. But the now this person from the age of 37 years. Such a day of the adoption.
There would have to be inquiry on that. And go only by.
But he has to approach the civil court first. That is the case. Yes, there's some from the civil court.
They have filed a 1 Rule 10 application.
Yes.
Appears to me. Anjanappa. Anjanappa. You served a copy of this application. 1 of 2023 has been filed for recalling the order dated 1/9/23, dismissing the above petition. On a non-appearance of the counsel for the petitioner. Accepting the said copy has been served on the counsel for the respondents. None appears for the respondent, nor are any objections filed to the said application. Accepting the reasons stated in support of IA 1 of 23, the order dated 1/9/23 is recalled. The above petition is restored to file, subject to payment of cost of rupees. Now, cost of rupees 2,000. Then we'll stop sitting beyond 440. The court says 2,000 rupees to the advocates plus benevolent fund. Released on 19th December. ಏನು ಕೇಳಿಸಿಲ್ಲ. You are appealing to the petitioner. For number 1. 2019 matter. At the request of counsel for the petitioner, released on 13th December, it is made clear that no further adjournment will be granted. If arguments are not advanced on that date, petitioner will be liable to dismiss the non-person. If a order earlier granted, the extension needs to. Come wherever it comes, be ready. Twenty-two. Have not been complied. Comply, Marty. Pending consideration of IA 2 of 23, counsel for the petitioner is permitted to comply with office objection. Relist on 2021 matter which has been dismissed, you are moving now without complying. Comply, madam. Relist on first week of January. ಒಂದೂವರೆ ವರ್ಷದಿಂದ you haven't complied. These objections you have not even appeared before the registrar. What is this? First week of January. Next. Objections to? Non-appearance when the affidavit active, non-filing when the affidavit active. Counsel for respond number 2361 is granted 2 weeks time finally to file its objections. Objections if any by 20th December, released on first week of January. When a given undertaking.
Same order.
The undertaking. Needless to say, the undertaking will continue of counsel for respond number 13 will continue till disposal. You are appearing for the proposed respondent, Mr. Any objections? Okay. 1 of 2023 has been filed. Who are you and why do you want them to come on record? At the end of the application, second wife and we plead the second wife and son, the alleged the second wife and son, with to represent proceedings since a death certificate has been sought for. But this is that you are for the hospital. R.B. Sadashiv, notice having been ordered, she R.B. Sadashiv, the constantly presented appeals to respond on 4 and 5. He submits, though he submits that he has no objection for the application to be allowed, he further submits that he does not admit the petitioner to be the wife of late Venkatesh. He's granted 10 days time to file a statement of objection. Objections if any to be filed only before 8, released on 14th. Also for the petitioner to carry out necessary amendment and file amendment fast.
What's happened before this was cancelled by the respondent. Before this on the board.
No interim relief. Is the third year? BJ Somyaji for respond number 1, 3, 1 and 3. Then HCGP for 2 and 4. Counsel for the petition for the 2 sets of the petition along with connection. 3 weeks time to obtain instructions, January. You are challenging the virus, you'll have to make the state a party. Rules virus challenge ಮಾಡ್ತಾ ಇದ್ದೀರಾ. Otherwise the constitution ಅಂತ ಹೇಳಿದ್ರು ಸ್ಟೇಟ್ ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು. ನೇಪಾಳದ ಶ್ರೀ urban development. Shri T.P. Vivekananda is directly accepted for respondent. Counsel for the petition to furnish two sets of the petition along with the annexures. Virus of the Karnataka Urban Development Authority's allotment of site rules 1991 is under challenge. It will be required for the petitioner to make state the party. Counsel for the petitioner is Karnataka represented by the Urban Development Department is brought on record as respond number 2. Counsel for the petitioner to carry out necessary amendment and file amended petition referred by 19, we list on January. Yes. Night watchman. Yes, Mitchell. His role was to keep us busy till you came. Yes.
Notice to the counselor who started comments.
He is appointed as an administrator.
Lord, they invoke a wrong provision.
He's been wrong or right,
Lord,
that will have to be decided.
Lord, maybe should be Lord that. Should be kind easy Lord that.
Which act? Municipalities.
They really brought to it. Kindly see Lord and accept it. This is an order.
Annexure?
Next year, April.
Yes.
This is an order electing the president and vice president. Kindly note, 6/11/2020.
Yes.
The tenure of the president and vice president. Under section 42 subclause 11. Each for a period of 30 months. After that, my lord, there is no election to the president and vice president. Under the normal circumstances, my lord, the election will, the power of president and vice president is of vacancy. Lordship will kindly see section 42 subclause 5. person can only exercise the power of the Adhyaksha and Upadhyaksha in the event of vacancy caused to the post of Adhyaksha and Upadhyaksha.
Perform the function of the president.
Yes.
Yes.
Now kindly see, my lord, 45
E5.
45 2A. So every councillor not is entitled for a meeting notice, because council has not the tenure of the council has not come to an end. Because they have a period up to 5 years from the date of the election. It is only vacancy of president and vice president. Therefore, the power of president and vice president can be exercised by the person appointed by the government to act as an administrator in place of president and vice president. Now, kindly see section 350. There are circumstances under which an administrator can be appointed.
Yes.
Whenever any general election to the municipal council under this act or any proceeding consequent thereupon have been stayed by an order of a competent board or an authority. This is one of the circumstances. Second, if the election to the councillor are more than 2/3 of the whole member of councillors of the municipal council.
Have you challenged the?
No, I am not challenged. But I am only I have no objection for him to exercise the power of president and vice president.
It said that he has been appointed as an administrator. So if you are saying that he cannot be an, though you say challenge it, Allah.
Do that exercise. But nevertheless, my lord, whether or not he can not invite or not give notice, my lord, to the councillor. As if, my lord, the council has become, my lord, is dissolved. He is acting as if the council is dissolved. And he has passed 40 resolutions, and he want to disperse the amount, my lord, to the work which has not been done. And he is doing so, Lord, if your lordship will kindly see, 40 resolutions in one day.
Where is the power of administrators?
Lord, your lordship will kindly see, kindly see, Lord, subclass 2. If these circumstances are available, he can exercise the power under 2.
Unless you challenge that. This,
now, Lord, he is dispersing the amount. Lord, necessary.
you file an application by afternoon. Without that.
The difficulty is copy of the order passed. The order appointing him as an administrator, not available immediately. Difficult.
These 3 reasons, A, B, and D, C having been omitted. What is that order about appointing an administrator and why he has been appointed as an administrator? We'll have to look
They
into it.
presume that, Lord, these things are available and appoint him as an administrator. The tenor of the order of
You got instructions, madam? That is the problem. He has the power to do it. If it is a valid appointment of an administrator, since you are not challenged the appointment of an administrator, he has the power to do all these things. Whether
it are the circumstances which my lord have seen, where Lord there is a vacuum for the entire council itself.
correct.
But there is no such thing, Lord, and the right of the councillor, Lord, is not taken away. Under these circumstances.
If the administrator is appointed, on the appointment of administrator in subsection 1, during the period of such appointment, the said municipal council and committees thereof, and the president and vice president charged with carrying out the provision of the act or any other laws, shall cease to exercise any powers and perform and discharge any duties or functions
That's the reason.
conferred or imposed
The
upon
very
them by or
appointment,
under. You'll have to challenge it, you'll have to see the appointment letter.
Yes,
If it is only contrary to 315,
yes. The appointment itself is illegal.
then your prayer will be maintainable. Without that, we cannot look into it. We pass it over, you challenge it, you place it on record, we look into it. If it is only a violation of 315, then we can look at your prayer that you sought for. Without that, we can't.
That is the prayer that is required to be made under the circumstances of the case. To advance the argument that we can only exercise the power of the president and the vice president. The power of the council, will be in that, and he has to follow all the procedures prescribed, for calling for a meeting and taking a decision.
So whether his appointment is in terms of 315 or whether it is in terms of 42.
Yes, that would be good person. If it
Because
is not, it cannot be covered under 315. Then even the order of appointment will be also good. Consequently,
Correct.
all the resolution passed also will not be happy.
Yes. So if it is under 42(5),
Yes.
then he can only exercise powers
The
of
power
the
of
president.
president.
He cannot pass these resolutions. But if he is appointed in 315 and is an administrator, he can exercise powers under everything.
Not there are no circumstances. As enumerated under 315.
That is only after you challenge.
Yes.
Then we'll have to stay that.
May I request you not to take this?
Yes.
The register of not be order. That Lord, he refers to 42, the Upakalam 5. That's ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳ ಚುನಾವಣೆ ನಡೆಸುವವರೆಗೂ ಪೂರ್ವಸಭೆಯಲ್ಲಿ ಸಂಬಂಧಿಸಿದಂತೆ ಕಾರ್ಯನಿರ್ವಹಣೆಗಾಗಿ ಅವರನ್ನು ಉಪ ವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮಾಡಬಹುದು. It appears, my lord, he has been appointed, my lord, only to exercise the power of Adhyakshya.
You still have to, where is that order? These are serious matters which will have an impact on the functioning of that council. If 40 resolutions are required to be passed, it has to be passed.
Yes, if it is not satisfy the test of 350. So what I see, Lord, here it indicates, Lord, that 42.
You'll have to place that order. You'll have to see that order.
I'm not able to get it, Lord.
Have we appointed him under 42(5) or 315? Pass over. Pass over. If he is appointed under 315, without a challenge, we won't interfere. But if he is under 42(5), then these resolutions he cannot pass. The president cannot pass that resolution. Only the council can. Since they don't have that copy of the order, they are not able to place it before. You have the copy, you will have to tell us whether the appointment is under 42. Tomorrow is Saturday. Madam, good dispute agutan. Big money also. That is why. Yes. This is a residential property or?
The petition probably the residential property.
What the respond?
Respond number 3, respond number 4. That property not has been used for commercial purposes. And it is facing a road which is complete. Well, the grievance is covered with respect to pollution which is caused by
Nuisance in terms of
noise and heat. Which lead that has been set up for the thing. The grievance is that the premises where the restaurant is situated far away from where the chimney is set up. Chimney is set up facing the residential premises of not this once the photograph and HSC page 23.
where is restaurant?
First, it's a what's the view? What's the other example?
Yes.
Is the silver color car.
The green color board
Green portion of the body.
is a restaurant. The chimney is put up in the back.
The back end of the property. This the restaurant is only and is running in only that particular portion.
Kitchen will always be in the back. Kitchen will always be in the back. Mr.
Is facing the residential premises
Wanted to face up. Where do you want it to face?
the other direction. Chimney is not based above the restaurant or the kitchen which is set up in the.
It's come up to the building level, building height. So the chimney cannot be at the restaurant level because there are number of floors.
Above the.
It's above.
On the.
At the most, you could probably say that the height is not sufficient. It should still go up.
But the height is not. The base 20 feet.
Yes.
The photographs. The bottom one. What's between the place where the restaurant is set up and where the chimney is set up.
So those rooms which are there are residential premises. Okay?
Those rooms are not being utilized as the lodges. They are lodges of the recent property.
So where are you?
The right side of the right side. The chimney. What's the right side? Like on page 25. The particular photograph. The green portion 1/3 is the property belonging to the artist.
How much of difference is there?
But is the motor is still kept over that motor of the.
There's no interim order that we can give you. Let us see what the comment said. The Pawan Kumar accept notice for respond number 1. Central Pollution Control Board.
Is there is a for inspection to be conducted by them to assess the.
Who is the standing counsel for CPS? Even Narelgi is directly accept notice for respond number 2. Gurraj Joshi for respond number 3. Notice to respond number 4. Returnable by 20th December. Respond number 3 is directed to cause the inspection of the property of respond number 4. The number 18 cross Sampige Road, Malaysia, Bangalore 560003, to ascertain if the restaurant is being run in compliance with the applicable pollution control regulations and requirements, and whether the chimney which has been installed is in accordance with the applicable rules. The inspection to be carried out commencing from 10:30 AM on 7th December, report by 14. Process fee by end of date. Very nice. Who is doing it? ಯಾರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ರೋಲ್? Area access notice to respond number. Is the accept notice for respond number 4. Of there being no acquisition of the asking. Devraj. In the event of there being no acquisition of the land of the petitioner for formation of the road, respondents are restrained from carrying out any demolition thereof. 2 copies. Taking the reasons stated in support of IA 1 or 23, products and certified copies of C, D, E and H are dispensed with. Conglomerate connected so and so 29. Yes. Yes.
A lot will say there is no problem, notification or regulation that is mentioned. There is no statement that I have violated the building plan. My Lord will also see the references to notice dated 17/8/2022, which is issued 17 months ago to me, wherein I am stated that the spot inspection has been conducted. And I've been found.
There's only a notice, you have to reply to it.
My Lord would see that we have stated that there will be. My Lord would see the.
That is what they will say always.
Hello,
But-
Annexure G, FA 73. My Lord will see the markings that have been made on my property for demolition. And my Lord will see the manner in this notice.
We'll observe that you reply, they'll consider your reply until they pass orders on it, they can't do any, take any coercive steps. And AGA accepts notice for respond number 1 for City Corporation, Sakshi M so and so, Urban Development Authority, same. We respond number 5.
There he has these notices of the issue.
Notice to respond number 5. He is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following release. The apprehension on part of the petitioner is that without considering the objections that may be filed by the petitioner to the notices dated 3/11/2023 at Annexure F and 17/8/22 at Annexure D, the respondents are likely to demolish the property of the petitioner. The schedule of Annexure F dated 3/11/23 indicates that it's only a notice calling upon the petitioner to place on record the necessary documents.
It's actually, notice is calling upon you, demolish my building myself. Telling which they will demolish the property. Because
Annexure F is page.
it's 72 months. Are they terrible police?
Where's 17/8/22?
That notice also on the present documents.
Ah.
On the ground of the Rajabala is encroached upon.
Okay.
But my lord would say that notice is issued immediately after there has been a demolition, unlawful demolition of my property. In respect to which an election fee, I have produced certain letter, my lord, that I have complained about this unlawful.
17/8/22 as a notice. Did you?
This is a petition notice, with respect to Rajabala, stating that there is a slab and some, a temporary toilet that has been constructed on the Rajabala, which they have disturbed. Which of the spot inspection, there is no notice of the spot inspection to me. In fact.
Have you replied to this, madam?
I don't know. Then I'm wondering.
Wait.
Just see my lord.
Pass over, you have some water and come back. Pass over. Asor Armin argument I will come time careful. Yes. What happened?
It's really, saying that we will show the properties which.
They given you a list, you should go and see. You want a guide and guided tour to the property.
When we change the property number, what I think that's. We need it once in weeks time we should. It's
Pending.
really,
But this small thing has been pending for ages.
we should.
When is the inspection scheduled? Both of you are not agreeable, we'll fix the date and time. So now we'll fix for each zone. ಯಾವ ದಿನ ಒಂದೊಂದು zone ಏನ್ ಯಾವ zone north east west south Rakesh Nagar, then east zone, Yelahanka zone, 3 zones are there.
Yes.
Memo dated 24/11/23 has been filed by the council for the petitioner, enclosing various documents on the properties identified. It is submitted that in furtherance thereof, the inspection, joint inspection will be carried out by the petitioner and respondent number 1. There being no dates and time fixed in the said memo or the accompanying documents, I deem it fit to fix such date and time. As the petitioner and respondent number 1 shall inspect the property situated in Rajraj Nagar, commencing from 10:30 a.m. on 28th November 2023, 29th November 2023. The property is located in the east zone, commencing from 10:30 a.m. on 4th December 2023. Property is located in the Yelahanka zone, commencing from 10:30 a.m. on 13th December 2023. Where should the petitioner report? To that particular ward of zonal office. The petitioner shall report to the concerned zonal office by 10 a.m. on each of those dates and meet with the whoever somebody respond. This is going on for 6 months for this. Who does a report to? To the assistant engineer. There will be number of assistant engineers. So assistant engineer which one word one day just AE what? AV estates and then to the concerned report to the concerned AE, details of which shall be furnished by Sri Karthikeyan by end of day tomorrow. By end of day Monday.
So, report to the state officer.
Estate officer is here.
Is here in the sector.
Estate officer is not coming with you.
No, let him other people do an officer, so that would be.
Go to the zonal office, otherwise it won't happen in one day. We live from 13th December. 14 this. 13th. 18 December. Rajeshwari. 2015. No chance. Password. You don't argue, we'll discuss. 2015 match. Password. On 16 matter, Mr. Nara. No password, you get him now, we'll take it as soon as he comes. Naik is very busy in the afternoon. Mr. Naik is very busy in the afternoon, so we'll take it now. Call your senior. He will come, I'll call him. So Mr. Naik, this is a 16 matter, Mr. Naik is busy in the afternoon, he wants an attendance. Then it will go to end of December. Yes. Yes, Mr. Arvind.
Petition. The petitioners in quality connected A, case number 71. Resolution passed by the board respondent majority. Giving license to the respondent to open an establishment of the rice mill in the. What is the land right? Case number.
Yes.
Connected A.
Hmm.
Majority. The petitioners earlier now filed the appeal before the honorable AD challenging the order annexed B, case number 47. It is pending consider the date appeal number 1030/16. Giving pendants of that appeal, delicately assure the application upon this order by order, giving lessons to the fifth respondent to establish so the rice mill would causes a great hazardous to the official advertisement of the petitioner. Adjacent land.
Will a rice mill affect the agriculture activity in Kerala?
Because the taking the activity regarding the knowledge comes to this field, then it affects to the other.
Road or Bharat. Lorries will come in the road, it will go in the road.
The road is similar. There is no any proper road.
Penally, it's a penally. ಎರಡು ಕಡೆ ರಸ್ತೆ
They have cut the regarding the question of land. It is just like before the honorable gave it. Communicated regarding pendants of the AD to the authorities, ACDC and also both responding. Despite that, the process is ordered.
What, it has been established or not established? There is no interim order.
No interim order, but the pendants of this before the AD, the rice mill is established.
Rice mill is established. Now that it is established, these reliefs are. Your only relief is considering your objections. There is no interim order granted. Now the establishment of the rice mill has already happened. Even again the objection established admin.
Not any causes regardless to the other activities of petition because it of very important.
Now you have to challenge the establishment of that. If they are not, how established? 2017 matter. ನೀವು ಇಷ್ಟ ದಿನ you are not even moved the matter ಅಂದ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ
That's why I keep it.
if there was a problem you would have moved the matter. There is no problem. Just want to create.
Conversion ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ, apply ಮಾಡಿದ್ದಾರೆ, we have given permission.
The purchase. If there is any complaint, you file it with the concern. Petitioner is before this court seeking for the following reliefs. By way of unexceptional resolution dated 28/4/2017, respondent number 1 was permitted to establish a rice mill. And respondent number 5 was permitted to establish a rice mill. The petitioner approached this court seeking for the aforesaid reliefs, contending that if the rice mill were to be established, the standing crops of the petitioners would be damaged. As also, the petitioner would be put to harm and injury. In the pendency of the above matter, the rice mill has been established and been running for the last nearly 5 years. That view of the matter, the petition has been rendered infructuous. There is no point to, there's no purpose of considering the objections now after the establishment of the rice mill. Message the petition stands dismissed. In the event of there being any grievance or any complaint of the petitioner as regards running of the rice mill, they would always be at liberty to approach the appropriate authority. Dated? What is the date?
28/11/20.
What's the matter about? Yes. Connect to so to release on 20. Yes. Hey. Yes, Mr. Irapari. Pending the let's see if he appears in the afternoon, otherwise we'll do. Also. Forty-seven. 47 adjourn ಆಯ್ತಪ್ಪ. You are representing in 47. 47 there is some bereavement in the family and it's been adjourned. The bereavement in the family of the councillor. It's been adjourned to some day. 13. Samir. Ashok. Ashok. Ravi Shankar. Ready? Ashok. You'll be appearing in all the matters. One, you are in another. Nageshri in the third one. Shivaram. Yeah, all of you are ready. ಕೂತ್ಕೊಳ್ಳಿ. ಎಷ್ಟೊತ್ತು ಗಂಟೆ? ಪವನ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಇವತ್ತು ಅಜ್ಜನ್ ಆದ್ರೆ 15 ದಿನ ಹೋಗಲ್ಲ. Consent what? He is not going to be here. Let's see the end of the list. You are ready, alva? Correct ಹೇಳಬಹುದು. Not ready ಅಂದ್ರೆ not ready ಅಂತ ಹೇಳಿ.
My matter, my lord. Sanction na cancel ಮಾಡಿದ್ರೆ ಆಫೀಸ್ ಇರೋ ಖಾತಾ. You produce a khata, everything will be all right. Corporation says it's no khata for the corporation. This is the issue. What is going on? One of the other reason, back in the last occasion, Nageshi madam was ready with the original papers of corporation saying that there is no khata for this property in the name of the petition.
Ready ಇಲ್ಲ ಅಂತ ಹೇಳಿದ. Ready ಇಲ್ಲ ಏನಪ್ಪ? We can't get out the arguments from him. You will have to do that. Council Shri Amit Deshpande seeks for and is granted. Isn't that ready agake? It is time to get ready and address his argument. We list on 27. Interim order earlier granted is extremely. Yes. The kata you have, e kata is not this.
It should be, it should have been. You also correct some benefits. Thereafter, in 2017, there is a circular that says that you have to issue certain layers. But I made an application, my application is not ready. Right, so without the ministry of honesty. That is. That's very good, responding to the issue and he can't take. They are doing the necessary rights. This is not authorized. Second one, give us a clear vision of the sanction. What happened to the area? In order to check out the ministry of housing rights, there is a circular clear idea. There is a sanction. They have to know that again rejected against those members orders and before the elections. We should begin with state elections. These state elections include implementation of elections will find it page number 18 and 19.
Yes. Office.
Communication for CH-18 minutes.
Yes.
Allows me, when we read out my dots, means the second paragraph. If somebody is simply, we are simply 1993, it was a very good article. Near Mar, 1993, it's put up, Nadara, Karnataka, Sahara, Vishwati, Madara, Yojana, Iraqi, and Manjurati, Parade, Super, Rati, Karagana, Manjurati, Parade, Nagara, Savannah, Vinas, and Mandura, Mari, name only, did the article, Tarani, each representative, was a banana, negation, PID number, near the Southern. This is the end of communication minutes. If I may just draw lots of tension minutes, the communication at page number P916.
P9.
Please. P9 minutes. The council justifies the issuance of the sanction minutes. But if I may read it out, make under the share of the survey number 179, 179 ದೇಶಕ್ಕೆ ಉಲ್ಲೇಖ ಬಂಧುಗಳಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆ ಆಗಿರುವಂತೆ ಉಲ್ಲೇಖ 2 ಸುತ್ತೋಲೆಯಲ್ಲಿ 3ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ if no planning authority is constituted in respect of any local planning area, then the improvement road, if any, constituted under any law of the 19 acres and jurisdiction over such local planning area is the planning authority. And if no improvement road is constituted in respect of any local planning area, then the Municipal Council itself is ತಿಳಿಸಿರುವಂತೆ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಈ ಕಚೇರಿಯನ್ನು ಬಡಾವಣೆ ನಕ್ಷತ್ರ ಅನುಮೋದನೆ so on. And then
This is a condition in the conversion order.
Please, this is there is a condition in the conversion order that you go to the planning authority, but there is also a subsequent something.
The conversion order issued by the deputy commissioner.
Please,
On what basis, what is the legal basis? That it is the municipal council itself will be the planning authority.
But it's the planning, the legal basis for this one is the circular minutes which the logics will find at page number 2022. Page number 20 minutes, when it goes up to page number 22. No, that's not correct. That
is the conversion.
Document minutes is at page number 28.
28.
Please. This circular minutes, I may read it out. It says that it appears that the conversion of land is permitted by the deputy commissioners. The town municipal council, city municipal councils are consulting the department of town planning, clearance of the limits of licenses. They need to consulting the department of town planning has been examined with reference to the relevant clause in the position indicated the formation and guidance for municipality. Paragraph 2, chapter 8, to give the power to the municipal council to formulate and implement subject to the condition and restrictions specified therein and constitution improvement with section 170 confers powers in the municipal councils, interrogate, sanction or refuse to sanction private trade. Now, public streets, etc. However, municipal councils cannot exercise the powers under chapter 8. The improvement boards are constituted in respect of town cities, so and so and so. Then I was over the page numbers of paragraph 3 minutes. The logics will see what is underlying this. If no planning authority is constituted.
local authority having jurisdiction over such local planning area. The wording is different. Wording of subsection 7 is different from what is being reproduced there. 7B. 7B of KTCPI. Not the municipal council, is the local authority. Local authority would be the municipal council. The corporate municipal council don't. Saying CMC, but it says local authority. So local authority could be the CMC, TMC, or the panchayat also.
They also have section 170 of municipal law.
Exactly. Yes.
Section 170 is best powers with the local planning authority to also issue sanction. Section limits also find the action limits in the circular which is made on the page 20.
Yes.
We now have page number 22. Find sanction. See the bottom right from this. Somewhere in the middle it says plan approved minutes. And this is minutes by resolution which bears number 63 minutes. And this was approved on 23/10/1991.
This approval is happening, they'll have to follow which law?
Number 170.
The approval. But what are the requirements of the plan sanction for being considered by the municipal council?
It has to be a release level of expenses.
There will have to be parks, open spaces. How many acres is this?
This is 3 acres, 32 acres.
5 hectares exemption. We'll come back and.
I'm getting fewer.
You are getting fewer. Enough fewer ಬಂದಿಲ್ಲ. ಏನು ಒಳ್ಳೆ submission. Yes, serial number 81. Have you informed the other side? ಅದೇ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
I am the petitioner.
ಆಯ್ತು, there are other councils, have you informed them? ಮಾಡಿದಿರೋ ಇಲ್ವೋ? ಮಾಡ್ತೀರಾ ಎಲ್ಲ? ಸುಮ್ಮನೆ ಕೂತು ಫೋನ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. Even the head counsel for the petition submit that he is not feeling quite well and as such seeks for, imagine we submit that he will keep the respondent counsels informed. On that ground, the matter is urgent. In the event of the respondent counsel moving the matter and submitting that they have not been informed, the matter will be taken up. Released on 12th December. 92. 92. Informed Mr. Krishna and Murli. It was the request of counsel for the petitioner released on 14th December. 69. Objections. ನಿಮ್ಮ ವಯಸ್ಸೇ ಜೋರಾಗಿದೆ ಅವ್ರದ್ದು. 59. Shri M.S. Devraj, the counsel for respondent seeks for and is granted 2 weeks time to file a statement of objection. Objections if any by first week of January. By 4th, released on 11th January. That's not the reason. Please wait. It's a dated matter listed today. It was to be argued today. Let everybody come. Have you informed everybody? Okay, Amit Deshpande has entered appearance for and the request of respondent Amit Deshpande, counsel for respondent number 1 and 2, released on 14th December. Adjournment argument ಮಾಡಿ. ಯಾವತ್ತು ಬೇಕು? 2019 matter, it's dated matter. ಯಾವತ್ತು you will be ready? 18. ಒಳ್ಳೆ ಡೇಟಾ ಹುಡುಕಿದಿಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಅಲ್ಲ. 56 released on 11th December 23. If arguments are not advanced on that date, the petition will be liable to be dismissed for non-prosecution.
Serial number 42 pertaining to that, had some advertisements there.
Yes.
But here, 3:30, therefore I would
We'll
request.
take it right now.
Anyway,
It's a 2015 matter.
no, not for that reason. I have some personal inconvenience in the sense at 3:30 and I have to.
All arguments advanced, only some 5 minutes left in that.
Madam Umbrella, 3:30 which I have to hold. I have
I
some.
42 at the request of counsel for the petitioner released on Monday, 27th at 2:30 PM.
Please.
Readings are complete? Readings are complete? No. Request of counsel for the petitioner released on 18th December. Continuation matter. So once the password ಮಾಡಿದ್ರೆ, you don't know whether it will reach. Password. Rakesh Bhatt. Password. Yes. But we'll impose costs on it.
But might also have to
Place something on record, we'll accept it. They are saying no.
I have messages from our opponent. I think it within myself. He is communicating with my wife. He is involved and the builder, not the owner. That is what I mean.
You place something.
Based on the communication messages, he made it party.
He was trying to broker peace between both of you and Tauro.
That is accepted notice which I issued to that property. At my address that I mentioned, is that very property. It doesn't mean that I am the owner.
What are you doing sitting in that property? Receiving notices. But how did you receive the notice? We'll give opportunity to both of you to place things on record. But if we find any of this one, we'll impose costs. Even though we will not impose costs on them. If you have those messages, whatever you want to place that they are, you are trying to mislead, then there's a problem.
Nothing would have happened. They didn't say that. In fact, they said we will see instructions whether to take notice for last five.
Yes.
Next day, nobody appeared for them. Even last day, when the compliance notice was filed by the BBMP, that's when from the records, there is other names that I could.
Place it on record.
In the application, I've set that out.
Application and some documents to say, otherwise it is your word against their word. That is not something which will help. This forms has been filed. Been freed. 3 persons on the ground that they are the owners of the property in question. Notice on IA so and so on the said persons. Emergent notice on so and so on the said person written by 19th December. Affidavit has been filed.
Affidavit has been filed. Yesterday.
23rd you have filed.
Yes, that was the order, my lord. Not before 23rd it has been filed.
What is the action that you are taking against this architect?
You have to understand that, she has instructed the board office to, issue a focus notice to the architect also. For an explanation as to how this inadvertent happened.
T59 was the direction to carry out inspection. Statement made is that they are informed about that petition only on 14/10. T59 is when notice was accepted on behalf.
Yes, but the inspection was to be carried out
Yes.
on 14th.
9/10. It was to be carried out 9/10.
9/10.
So the allegation now being made on the advocate. The advocate informed only on 14/10.
Kumar had taken the notice. You could just what the thing, and then I could send the message.
Doesn't Mr. Pawan Kumar say inform what is to be done?
That's as far as informed by Mr. Pawan that he had informed the legal cell as well as the local office.
Then why is the
Board
statement?
office. But it had to go to the ADTP office. So
We are not concerned, ADTP, AEE, CE, SC, we are not concerned. BBMP is one, once the order is passed, is BBMP.
it is delayed by the time you could get.
Not 3 days, Mr. Karthikeyan.
92 before
The order is 25/9, it was informed on 14/10. The 20 days delay is the allegation made now virtually against the lawyer.
but the legal cell on the same day.
Then why is the statement?
By the time it could reach the person who has to conduct the ADTP, who has to conduct the spot inspection.
That's your internal functioning. Because this date has very much relevance.
It was on 10/10,
You sanction the plan.
on 10/10.
Well, then you sanction the plan
Plan gets issued.
and very conveniently you say the panel advocate informed on 14/10. The order was passed on 25/9.
25.
It's a very convenient date.
But this is, it's not that it was done on purpose. But
It appears to be done on purpose. Appears to be done on purpose.
The inspection was carried out way back in the month of April.
We are not concerned with that the inspection. We are concerned with the inspection pursuant of 25(9). If that was informed on that very day, that inspection has to happen on 9/10. You did not do an inspection on 9/10.
Communication has been sent by.
So why did the inspection not happen on 9/10 and knowing fully well that the petition is pending and knowing fully well that there's an interim order passed in this matter? You issue the plan sanction on 12/10.
If the inspection was carried out. It's the very next word.
This will be contempt even of the by the chief commissioner.
Only due to administrative reasons, but there is no intention to delay.
The effect is that the convenient date is, if that date was not there, we would not have made much about it. We would say, okay, not happened. In many a time, we have given you further time. But in this particular case, you are required to inspect on 9/10. You did not do the inspection. 10/10 you approve on the basis of the NOC. 12/10 you issue the sanction plan. Then you say, I came to know about the order only on 14/10. Because if you had come to know about the order earlier, you could not have issued the plan sanction. That's a convenient insertion of date.
Only administrative delay.
And the administrative delay and latches. This is completely modified.
Has been sent on the 26th itself. The information has been sent on the 26th itself.
How did you sanction it on 14/10 when you were aware of the order passed?
12/10. Then, the VWSSB NOC comes.
If the construction is being carried out contrary to sanction plan, respond number 1 and 3 shall ensure that there is no further construction if required by taking police help. Is the order passed?
Communicated, perhaps, with what there are records to show that.
Then we'll need a better affidavit of the chief commissioner. Please inform him that if he's trying to shield somebody, he'll also be in trouble.
No, that's probably administrative reasons.
Not been said here.
File of the zonal office, the ADTP itself, probably, how the lapse of that case happened in 5 days.
What is the point in passing orders by this court if you have a lapse of 5 days in your case?
So,
the order becomes effective on the date it is passed and communicated to your council.
the council has communicated with us on time. Council has communicated.
So how did you sanction the plan on 14/10?
It happened, computer automatically generated.
Automatic ಏನು ಆಗಲ್ಲ.
The PWSSB NOC got uploaded on 12/10, it got issued. Because the deemed upload only subject to the PWSSB. What inspection was carried out, plans are submitted.
Construction has been made without plan sanction,
Only subject to the PWSSB.
100% violation of the setbacks. Everything happens automatically.
From April, they start constructing another sample.
How did they
Subject
start?
to the, NOC of PWSSB being submitted. Just everything was okay. Plus, we carried on with it. But immediately the inspection was carried out and 253 was also, 248(3) is also being issued.
Affidavit of the chief commissioner has been filed in Roman 9, subpara Roman 9 or para 3. It is that the information regarding the present writ petition was received through phone from DVMP panel advocate on 14/10/2023, which is the second Saturday, to conduct spot inspection. And hence immediately on the next working day, that is 16/10/23, a spot site inspection was conducted by the officials. And on inspection, deviations being found. Notices under subsection 1 of section 248, confirm provisional order under subsection 1 of section 248. A notice under subsection 2 of section 248 was issued. the aforesaid dates appear to be too convenient to be true. Inasmuch as this court, while ordered 16/11/23, directed the inspection of the property to be conducted from 10:30 a.m. on 9/10/2023. A notice was issued to the panel council. On 25/9/16. Not 25/9, which is direct. Okay. Something from 10:30 a.m. on 9/10/23. This court had also directed that if construction is being carried out contrary to the sanction plan, respond number 1 and 3 shall ensure that there is no further construction. In the present case, admittedly, there was not even a sanction plan which had been issued until 16/10, until 12/10/23. Panel council has been put on notice, and I am being aware of the interim order which had been passed. Again, contention is communicated when? 26/9. B.S. Karnataka has built that the said order was communicated to the officials of the corporation on 26/9/2023 itself. If that be so, the amendment made in para Roman 9, subpara Roman 9 of para 3 by the Chief Commissioner is not proper and correct. Or rather, it can be said to be a false statement. Since in the affidavit at no place is the reference made to the communication made by the panel council on 26/9/23, it sought to be considered as if the information was conveyed only on 14/10/23. As afore observed, this date appears to be too convenient, inasmuch as the plan which had remained unsanctioned came to be sanctioned on 12/10/2023, after the date fixed for inspection by this court. The Chief Commissioner is put on notice. These facts is directed to file a better affidavit detailing out the actual state of affairs by examining the files by himself and not signing any affidavit prepared by his junior officials and placed before him. As I find that the affidavit now filed by the Chief Commissioner identical to the one filed by GDTP on 16/11/2023, except for the details of the deponent and para 1. Such affidavit to be filed on or before on or before 6th December, relist on 8th December. Now the construction is stopped. The problem is that you are not probably keeping the Chief Commissioner informed. Your officers are not, you and the new Allah. Your officers are not keeping the Chief Commissioner informed of what is happening. He doesn't know what your officers are doing. And they are misleading him. Finally, the contempt will have to be faced by him if we initiate contempt. That's why we are giving this opportunity for him to inquire into and file the affidavit. If not, we will initiate against the concerned person. You're misleading and suppressing facts from the Chief Commissioner. It's not good.
JDTP could file it never so better explaining it.
Not the JDTP.
The delegated authority never.
We are not sure about your delegation. There are no rules.
They say that the architect has put the wrong thing.
That is in the said affidavit of the Chief Commissioner, it stated that the registered architect has inadvertently fixed the seal of the JDTP north when it should have been JDTP south. It is not understood as to, is not known as to how a registered architect can affix the seal of the JDTP and how the same has been outsourced or delegated to an architect. The submission of Shri B.S. Karthikeyan that necessary show cause notice has been issued to the architect.
Letter seeking explanation.
Letter seeking explanation has been issued to the architect. Is placed on record. Once the explanation is received, the same to be placed on record of this file. Yes.
Construction is now going on for almost 6 months. Almost there is the first. Why doesn't the BBMP know that there is a construction going on when they very well aware that the plan is not completed?
That we are dealing with in another matter.
Maybe the 248 notice does not indicate a timeline. Doesn't say within 15 days or any timeline is not given. Because the 356 requires a timeline to be set out in the order, which remove the.
And that we are dealing with in another matter, in two different matters. Both the issues are in two different matters. Let's not mix everything here.
Also, in the lordship, if I may recollect from the order sheet, the petitioner's property also had to be inspected.
Yes.
But on the said date, they did not allow us to inspect because they went on this. So they would want to inspect it.
So when will you inspect? When do you want to inspect? That counsel for respond number 1 to 3 submit that the petitioner's property could not be inspected. We submit that if a date is fixed, date and time is fixed, the inspection will be completed and report filed. The inspection is now rescheduled on 29th September, commencing from 29th November, commencing from 10:30 a.m. Report to be submitted by date next morning. Report to be filed on or before 5th December, released on 11th December, and 19th amendment. 6th, let it be filed and it will be listed on 11th. How can you carry out the amendment? Notice has to go. The available warrant issued to, since there is a contention raised that respond number 5 has nothing to do with the property. The available warrant issued to respond number 5 is recalled for now. Counsel for the petitioner to place on record how respond number 4 and 5 are related to the property and or the construction. You'll have to challenge it. Yes. And SCGP accepts notice for respond number 1, 5 and 7. It's 1 to 5.
Yes.
SC Shivramu for respond number 3, Mandya. 3, 4, 3 and 4. PP Vivekananda for respond number 7. Issue notice to respond number 6, returnable by 18th December, that SCGP has filed a memo dated 23/11/23 stating that the appointment of the administrator has been made under section 315 of the Karnataka Municipalities Act 1964. The petitioner seeks for, is granted a week's time to.
I seek for a short password.
You'll have to challenge it.
We will challenge it. Lots of have it on Monday.
Seeks for and is granted a week's time to file necessary application to challenge the said notification. Relist on
Monday is also.
6 December.
Until then, some protection we can do.
Can't give you any protection. It's a valid appointment unless we find it otherwise.
Because the Lordship may kindly see the first paragraph. It's filed under 42A.
315 ಅಪ್ಪ.
ಅಲ್ಲ, ಅದು ಮುಂಚೆ
ಅದು
Lordship may
ಆಗಿದೆ.
kindly pass over. Senior counsel is always late. Lordship may kindly pass over.
See, until you, there's no, if you pass over, it's not going to reach anyway. And until you challenge it, like morning we told you, nothing can be done. First challenge it. You could have filed it by now. We told you that also. Yes. Madam. Did you reply to that notice, Annexure F,
The second notice, which I'm challenging is, I'm challenging.
Annexure D?
Hello, Annexure F includes, states that I'm an encroachment for buffer zone, which my lord would notice is not mentioned in Annexure D at all.
Did you,
I'm marking
did
the
you
annexure.
reply to Annexure D?
My lord, what will happen was that annexure, my lord would only take annexure C for a moment, which is at page 67.
Yes.
In annexure C, I complain about the illegal action of the corporation in demolishing a portion of the boundary wall and a toilet in my property on 31/7/2022, which was a Sunday. On 1st of August, I give this complaint. Thereafter, 7 days later, belatedly a notice was issued to me saying that the spot inspection was conducted, and I was found to have built a urinal over a Rajakalu. That urinal had already been demolished on 31/7/2022 through an illegal action. Thereafter, the second notice is given, my lord.
You can argue all that.
My
Did you reply to 17/8/22?
My lord, I have, my instructions are that the petitioner trust official met with the representatives of the corporation, and I placed all the records before the corporation, but there is no acknowledgement copy of it
If
available.
you don't reply,
My only submission is
then
this.
orders will be passed.
No, my only submission is this, my lord. My lord would see that annexure F has no foundation in annexure D apart from mentioning it at reference. My lord would also notice that 17 months have elapsed from the date of the first notice to the date of the second notice. With respect to the first notice, it was about a urinal on a Rajakalu which has already been demolished. The material on record shows that it's already demolished. The notice that I am now challenging, which has been issued on 3rd of November, is with respect to an encroachment in a buffer zone area, of which no notice has been given to me.
Please read Annexure F.
My lord, annexure F says, my lord would see the mischievous language employed there. Because if I may read the second paragraph, it says.
Read the first paragraph.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತುಮಕೂರು ನಗರದ ವಾರ್ಡ್ ನಂಬರ್ 3 ಶಿರಾಗೇಟ್ ನಲ್ಲಿ ಶ್ರೀ ರಾಜಾರಾಮ್ ಅಂಜನಾ ಪಟೇಲ್ ಸಮಾಜ ಸೇವಾ ಸಂಘದವರು ರಾಜಕಾಲುವೆಯ ಹಾಡಿಯನ್ನು ಬದಲಿಸಿ ಕಾಲುವೆ ಮೇಲೆ ಸ್ಲಾಬ್ ಹಾಗೂ ಶೌಚಾಲಯ ನಿರ್ಮಿಸುವುದಾಗಿ ಅರ್ಜಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿ ರಾಜಕಾಲುವೆ ಮೇಲೆ ಸ್ಲಾಬ್ ಮತ್ತು ಶೌಚಾಲಯ ನಿರ್ಮಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. This is the subject matter of the 17/8/2022 notice, my lord, where this toilet had already been demolished as on that date.
Yes.
Thereafter, my lord would see ಮುಂದುವರೆದ ಉಲ್ಲೇಖ 1ರಂತೆ ನೋಟಿಸ್ ನೀಡಿದ್ದರೂ ಸಹ ರಾಜಕಾಲುವೆ ಮೇಲೆ ಸ್ಲಾಬ್ ಮತ್ತು ಶೌಚಾಲಯ ನಿರ್ಮಿಸುವುದನ್ನು ತೆರವುಗೊಳಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಕೋಡಿ ಹಳ್ಳದ ಬಫರ್ ಝೋನ್ 9 ಮೀಟರ್ ಇದ್ದು ಬಫರ್ ಝೋನ್ ನಲ್ಲಿ ಕಟ್ಟಡ ಆವರಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. No foundation for this, my lord. In fact, there's no 9-meter buffer zone that's demarcated in the zonal regulations. That produces zonal regulation along with my petition. This is comes up for the first time in the second notice, purely matter of idea, without jurisdiction. And it says, if you do not demolish this, we will demolish this. My lord would say that on the next page, on 73, I've produced the photographs where they come in illegally already made markings on my building.
It shows the zonal regulations.
The zonal regulations is page 74, man.
Where is the buffer zone?
There is no demarcation of any 9% buffer zone, 9-meter buffer zone anywhere in the zonal regulations, my lord. The only place where a no development zone is indicated is, my lord would say at the bottom of page 93. But I've given to understand that any buffer zone demarcation is only with respect to lakes. This is from Kodi Halla, they're saying that I have violated, I've encroached in the buffer zone. But my submission, my lord, is that no notice has been given to me. I've not been heard on this issue at all. There is no demarcation in the zonal regulations for any buffer zones. In fact, I inquired in the Tumakuru Municipal Corporation, and we told that only for lakes there is a demarcation. 45-meter buffer zone. There is no 9-meter buffer zone demarcated anywhere in the zonal regulations. With respect to Halla streams or my lord would also see the
SCGP accepts notice for respond number 1. City Corporation. Akshay M. Krishna for 2 and 3. Urban Development Authority. Akshay M. Krishna 3 and 4. But if there is no buffer zone fixed,
I'll make my submission.
you make your submission, we'll stay in the demolition. You should not demolish by that time.
The instructions are in the submit.
Get your,
Wednesday.
till then, don't know demolish. Notice to respond number 5 is deferred till next day. Sakshi M. Krishna seeks for and is granted 3 days time. She seeks for and is granted 3 days time to obtain instruction, make a submission as regards the existence or otherwise of buffer zone. Till then, the respondents are restrained from any manner taking any coercive steps, including demolition of the property of the petitioner till the next day. You will make your submission, madam, but if your officers go and demolish, what will you do? What will we do? If there be an order. 29th. Also for the petitioner furnish 2 sets of the petition along with annexures on the opposite councils.
Kindly onto page 14, Your Lordship.
14. Yes.
ಇಷ್ಟಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕುಂದಾಪುರ ತಾಲೂಕು ಬೆಳ್ಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 98/2/17 ಹಾಗೂ ಸರ್ಕಾರಿ ಸ್ಥಳಗಳಿಗೆ ಕುಂದಾಪುರ ತಾಲೂಕು ಬೆಳ್ಳೂರು ಗ್ರಾಮದ ವೈ ದಿನಕರ ಶೆಟ್ಟಿ ನಾಗಶೆಟ್ಟಿ ರಘುರಾಮ ಶೆಟ್ಟಿ ನಾಗಶೆಟ್ಟಿ ಕೆಲ ಗ್ರಾಮಗಳು ನಮ್ಮನ್ನು 50ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅಕ್ರಮ ಸಕ್ರಮ ವರದಿಯಲ್ಲಿ ಪ್ರತಿ ಜಮೀನನ್ನು ಮಂಜೂರಾತಿ ಪಡೆದಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 1 ವಿರುದ್ಧ ಕಿರುಳು ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿಗಳನ್ನು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ವೈ ದಿನಕರ ಶೆಟ್ಟಿ ನಾಗಶೆಟ್ಟಿ ಮತ್ತು ರಘುರಾಮ ಶೆಟ್ಟಿ ಅವರು ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ಮತ್ತು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರ ನ್ಯಾಯದಲ್ಲಿ ದಾಖಲೆ ಹೊಂದಿರುತ್ತದೆ. ಕಾರಣ ಮಾನ್ಯ ಕರ್ನಾಟಕ ವಿಧಾನ ಪರಿಷತ್ ರಾಜ್ಯ ಸಮಿತಿಯ ಸಭೆಯಲ್ಲಿ ನೀಡಿದ ಸೂಚನೆಯಂತೆ ಸರ್ಕಾರ ದಾಖಲೆಯನ್ನು ಅನಧಿಕೃತವಾಗಿ ತಿದ್ದುಪಡಿ ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ ವಂಚಿಸಿರುವ ಕುಂದಾಪುರ ತಾಲೂಕು ಬೆಳ್ಳೂರು ಗ್ರಾಮದ ದಿನಕರ ಹಾಗೂ ನಾಗೇಶ್ ಶೆಟ್ಟಿ ಹಾಗೂ ರಘುರಾಮ ಶೆಟ್ಟಿ ನಾಗಶೆಟ್ಟಿ ಮೇಲೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಸೂಚಿಸಿದೆ. This complaint is lodged by the Tahsildar based on the instructions of the Legislative Council, the committee. Based on that, FIR was registered.
ವಿಧಾನ ಪರಿಷತ್ ಅರ್ಜಿ ಸಮಿತಿ ಅಂದ್ರೆ ಏನು?
ಏನು ನನಗೂ ಗೊತ್ತಿಲ್ಲ ಅದು. ವಿಧಾನ ಪರಿಷತ್ ಅರ್ಜಿ ಸಮಿತಿ ಅಂತ
ಸಮಿತಿ ಅಂದ್ರೆ ಏನು?
It is regarding to the encroachment.
ಅರ್ಜಿ ವಿಧಾನ ಪರಿಷತ್ ಅರ್ಜಿ ಸಮಿತಿ. ಅರ್ಜಿ ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ವಿಧಾನ ಪರಿಷತ್ ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಸೆಂಬ್ಲಿ ಸಮಿತಿ ಕಮಿಟಿ. ಸೊ ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಸೆಂಬ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಕಮಿಟಿ ಅಂದ್ರೆ ಏನದು? What does that mean? Which is this committee? For the prosecution. This is the foundation. Yes.
Based on that, your lordship, the Tahsildar has filed a complaint, your lordship. Now, what it transfers, your lordship, the complaint is not by the case of the Tahsildar. Tahsildar filed the complaint, your lordship, on another committee now. Now, look into the FIR, your lordship, what was registered on. Previous page.
Yes.
ಬೆಂಗಳೂರು ತಾಲೂಕು ಗ್ರಾಮದ 1998 ಇತರ ಸ್ಥಳಗಳಿಗೆ 1ನೇ ಆರೋಪಿಯು ನಮೂನೆ 50ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅಕ್ರಮ ಸಮಿತಿಯಲ್ಲಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಮಂಜೂರಾತಿಪಡಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಕರ್ನಾಟಕ ವಿಧಾನ ಪರಿಷತ್ ಅರ್ಜಿ ಸಮಿತಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಮಿತಿಯಲ್ಲಿ ನಡೆದ ವಿಚಾರಣೆಯಲ್ಲಿ ಮಂಜೂರುದಾರರು 1ನೇ ಅರ್ಜಿಯಲ್ಲಿ ನಿರಾಕರಣೆ ಪತ್ರ ನೀಡಿರುವುದಾಗಿ ತಹಸೀಲ್ದಾರರು ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿದ್ದು, ಅಲ್ಲದೆ ಕುಂದಾಪುರ ತಾಲೂಕು ಬೆಳ್ಳೂರು ಗ್ರಾಮದ 50ರ ವಹಿಯಲ್ಲಿ ವಿಡೇಯಕ ನಕಲನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ 1ನೇ ಆರೋಪಿಯು ಅರ್ಜಿ ಸಂಖ್ಯೆ 22793 ಸರ್ವೆ ನಂಬರ್ 79/2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾತಿ ಕೋರಿ 10/5/99 ಹಾಗೂ ಅರ್ಜಿ ಸಂಖ್ಯೆ 22836 ಸರ್ವೆ ನಂಬರ್ 2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಿ ಕೋರಿ 1891ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಮತ್ತು ರಾಜೀವ ಶೆಟ್ಟಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ 2285ರಲ್ಲಿ ಯಾವುದೇ ವಿಸ್ತೀರ್ಣ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ ವಿಸ್ತೀರ್ಣ ನಮೂದಿಸದೆ 25/90 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು. ಬ್ರದರ್ಸ್ ರಾಶಿ ಬೆಲ್ವೆ ಗ್ರಾಮದ NCR CR 22793 1ನೇ ಆರೋಪಿ ಹೆಸರಿನಲ್ಲಿರುವ ಅರ್ಜಿಯನ್ನು 2ನೇ ಆರೋಪಿ ರಘುರಾಮ ಶೆಟ್ಟಿ ಎಂದು ಅರ್ಜಿ ತಿದ್ದುಪಡಿಯಾಗಿರುತ್ತದೆ. ಬೆಲ್ವೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 2285 ರಲ್ಲಿರುವ ದಾಖಲೆ ರಾಜೀವ್ ಶೆಟ್ಟಿ ಹೆಸರು ತಿದ್ದುಪಡಿಯಿಂದ ದಿನಕರ ಶೆಟ್ಟಿ ಅರ್ಜಿ ತಿದ್ದುಪಡಿಯಾಗಿತ್ತು. Now your lordship, looking at the charge sheet documents are produced subsequently along with the memo, your lordship.
22793 was filed by
22793 was filed by your lordship. Why Raghuram Shetty? Why? What is the text, your lordship? 22793.
Raghuram Shetty.
ಹೆಸರಲ್ಲಿರುವ ಅರ್ಜಿಯಲ್ಲಿ 2ನೇ ಆರೋಪಿ ರಘುರಾಮ ಶೆಟ್ಟಿಯಲ್ಲಿ ತಿದ್ದುಪಡಿಯಾಗಿರುತ್ತದೆ. 1ನೇ ಆರೋಪಿ ಹೆಸರಲ್ಲಿ ಇತ್ತು ದಿನಕರ್ ಶೆಟ್ಟಿ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ದನ್ನ ರಘುರಾಮ ಶೆಟ್ಟಿ ಅಂತ ಮಾಡಿರುವಂತದ್ದು.
ದಿನಕರ್ ಟು ರಘುರಾಮ್.
ಹೌದು, ಅದಕ್ಕೆ ಪ್ರೊಡ್ಯೂಸ್ your lordship, it's page 39.
22836.
22836, your lordship. It is in the name of Dinakar Shetty only.
ಅದೇನು ಚೇಂಜ್ ಆಗಿಲ್ಲ. 22850.
22850, that was in the name of Rajiv Shetty. That has been changed into Dinakar Shetty ಅಂತ ಹೇಳುತ್ತೆ. This is the applications.
So now Rajiv Shetty goes out.
Goes out.
One Dinakar to Raghuram. Dinakar, Rajiv Shetty to Dinakar. Yes.
Goes out. So these applications, your lordship, for a kind moment, your lordship, turn to page 37 of the documents I produced, your lordship. Charge sheet documents, subsequent along with the memo I produced, your lordship.
37 of this.
Page, your lordship. Your lordship, kindly turn to page 37.
Yes.
But your lordship.
Yes.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ವೈ ದಿನಕರ ಶೆಟ್ಟಿ ಅಂತ ಇದೆ. What the prosecution says, this was in the name of Rajiv Shetty.
2850.
Yes.
Yes.
ಅದರ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಪೇಜ್ 39 ಅಲ್ಲಿ. That was your lordship, why Raghuram Shetty. It was in the name of ದಿನಕರ ಶೆಟ್ಟಿ. ಇತ್ತು, ಅದನ್ನು ರಘುರಾಮ ಶೆಟ್ಟಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ತಿದ್ದುಪಡಿ ಮಾಡಿ ರಘುರಾಮ ಶೆಟ್ಟಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ನೆಕ್ಸ್ಟ್ ದಿನಕರ ಶೆಟ್ಟಿ ಇದೆ. Now my submission, your lordship, these documents, your lordship, is the applications. Either a possibility also that, your lordship, during the filing of the applications, now correction ಮಾಡಿಕೊಳ್ಳುವಂತ possibilities ಇದೆ. Even assuming, your lordship, that I have manipulated the document, your lordship. These documents, once I have filed, your lordship, before the moment I am assuming that I have not corrected ಅಂತ ಇದ್ರು. After filing, your lordship, it is the domain of the custody of the authorities. I have no access to change the documents.
After this application was filed, in whose name was the allotment made?
Allotment has been made, your lordship, that your lordship get it, charge sheet, your lordship.
And who is the complainant?
Complainant is the Tahsildar. He is the one of the members of the committee, granting committee.
Yes.
He is one of the members of the granting committee. Now he files a complaint based on the legislative council Arti Parishilana committee of Karnataka.
Yes.
Now my lordship, can you turn to the charge sheet, your lordship, that is at page 25.
This document.
Yes, my petition,
Petition.
my petition.
Yes.
ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯಲ್ಲಿ ಕಾಲಂ 12ರಲ್ಲಿ ಹೆಸರು ತಿಳಿಸಿದ ಆರೋಪಿಗಳಾದ ವಿರುದ್ಧ ಹೊರಿಸಲಾದ ದೋಷಾರೋಪಣೆಯೆಂದರೆ ಆರೋಪಿಗಳ ಟೋಟಲ್ ಇಟ್ ವಾಸ್ ನೌ ಡಿವೇಟೆಡ್. ಆರೋಪಿಗಳ ತಾಯಿ ಶ್ರೀಮತಿ ಚನ್ನಮ್ಮ ಶೆಟ್ಟಿಯವರ ಹೆಸರಲ್ಲಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ 5 ಎಕರೆ 55 ಎಕರೆ 5.55 ಎಕರೆ 1ನೇ ಹೆಂಡತಿ ಆರೋಪಿ ಶ್ರೀಮತಿ ಸುಗನ್ ಶೆಟ್ಟಿಯವರ ಹೆಸರಲ್ಲಿ ಬೆಂಗಳೂರು ಗ್ರಾಮದ 4.7 ಎಕರೆ ಜಮೀನು ಇದ್ದು ಆರೋಪಿಗಳು ಸರ್ಕಾರಕ್ಕೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಅದನ್ನು ಮರೆಮಾಚಿ ಇನ್ನು 1ನೇ ಆರೋಪಿ 2291ರಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಯ ಹೆಬ್ಬಿ ತಾಲೂಕಿನ ಹಿಂದಿನ ಕುಂದಾಪುರ ತಾಲೂಕು ಬೆಂಗಳೂರಿನ ಸರ್ಕಾರಿ ಜಾಗದ 273ರಲ್ಲಿ ನಮೂನೆ ಸಂಖ್ಯೆ 50 ಅರ್ಜಿ ಸಂಖ್ಯೆ 2 ಎಕರೆ 15 ಸರ್ಕಾರಿ ಜಾಗಕ್ಕೆ ಅಕ್ರಮ ಸಕ್ರಮ ಸಮಿತಿಯಲ್ಲಿ 1880 ಮಂಜೂರಾತಿ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾನೆ. ಈ ಜಾಗವನ್ನು ಮಂಜೂರಾದ ಬಳಿಕ 98 ಆರೋಪಿ ಹೆಸರಿಗೆ ಪಹಣಿಯಾಗಿ 20 ಸಲ್ಲಿಸಿಕೊಂಡಿರುತ್ತಾನೆ. ಈ ವೇಳೆ ಖಾತಾ 250 ಅರ್ಜಿಯಲ್ಲಿ 2 ದಾಖಲೆ ರಾಜಶೇಖರ ಹೆಸರನ್ನು ತಿದ್ದುಪಡಿಯಿಂದ 1ನೇ ಆರೋಪಿ ತಿದ್ದುಪಡಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾನೆ. ಹಾಗೂ 1ನೇ ಆರೋಪಿ 98ರಲ್ಲಿ ನಮೂನೆ 50 ಸಲ್ಲಿಸುವುದನ್ನು 2ನೇ ಆರೋಪಿ ಹೆಸರನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಅಕ್ರಮ ಸಕ್ರಮದಲ್ಲಿ ಮಂಡಿಸಿದೆ. Now, what your lordship, these documents have been manipulated after I filed the documents before the authorities. I have no access to the documents.
Yes.
No access to the documents. My submission, lordship, these documents, your lordship, now, what is transferred in the FIR and what is transferred in the charge sheet is totally different.
Totally different ಹೆಂಗ್ ಹೇಳಕ್ಕ?
ಅಲ್ಲ ಮೇಲೆ ಆರೋಪಿಗಳು ಚಂದಮ್ಮ ಮತ್ತು ಇವರು ಹೆಂಡತಿಯಲ್ಲಿ ಜಾಗ ಇಟ್ಟರು ಬೇರೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಅದು ಇನ್ನೊಂದು ಅಡಿಷನಲ್ ಬಂದಿದೆ during investigation.
Yes. That is your lordship.
It started with
ceiling limit was there.
It started with
Yes.
manipulation. They found out these
Now
things.
my submission only this much, your lordship. These documents, what is transfers now, your lordship, is the applications which I have filed, your lordship. On what basis, your lordship, can we assume that it is manipulated? Well, even well hand I can, before filing your lordship, I can.
That's a matter of trial, Mr. Matter of trial. Today you are on 482 for quashing. What is the ground that you are, legal ground that you are trying to make?
My submission, your lordship, now, my another submission, lordship. What is the Arji committee? Where they have given the inquiry to conduct me and make me submissions. They have not called for any inquiry against me.
Inquiry in a criminal matters if there's a manipulation.
Complaint.
Not a civil matter where show cause notices.
No, your lordship, this committee, your lordship, what they says, ಈ ಮತ್ತೆ ದಿನಕಶಕ್ತಿ ನಾಗಶಕ್ತಿ ಅವರು ಕರ್ನಾಟಕ ವಿಧಾನಸಭೆ ಅರ್ಜಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ನೀಡಿದ ಸೂಚನೆಯಂತೆ ಸೂಚನೆ ತರಬೇಕೆ ನನಗೆ
ಅದು will ask, which is this committee will ask.
What is that committee? Who conducted the inquiry on that? To whom the notes are issued? Whether I have given an opportunity for that?
Yes.
There is a serious allegation against this petition.
Now, which is this committee which is supposed to conduct an inquiry?
My lord,
The name itself doesn't make any.
my lord,
Could be there.
Committee they are mentioned.
Indian committee.
I will verify, my lord. With respect to the.
What is the committee? What are its powers? What inquiry did it conduct? And are they related to this particular issue?
I will verify.
Everything is based on their recommendation.
The recommendation only Tasila.
Yeah. The committee, if it exists, then it exists. We'll have to just place it on record. Talking for some time, learned CGP 6 fund is granted. It's in our. A week's time to obtain instruction, make his submission as to the nature of the committee mentioned in the letter date 13/5/2016. In a complaint of the Tahsildar dated 13/5/2016 at Annexure. At page 14 of the petition. List on 29th, 29th the first. First.
Is that it?
Or request of both the councils relist on. Appearing for 46 ಅಲ್ಲಿ appear ಆಗ್ತಾ ಇದೆ. Irappa Reddy. And appears for the petition though called twice, once in the morning session and once in the afternoon session to give one more opportunity for the petition to be represented. Relist on 18th December. And appears for the petitioner though called twice. Appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Lord, is it 48, my lord?
Yes, Mr. Zamir.
I'm so sorry, my lord. I was not able to hear when it is.
Yes. Did not appear in the morning also.
My lord, I was in court hall 3. I'm so sorry, my lord.
Yes.
Lord,
Yes.
this petition, Lord, filed challenging the impugn notices issued by the respondents.
Hmm.
Nonetheless, my lord, in the writ petition 18907 of 2017, my lord, disposed on 4th July 2023.
Yes.
Lord, this should be, my lord, covered under that order.
Yes.
Therefore, my lord, I have to concede to that order, my lord. I have no other option.
Yeah, that 18907 order. Petitioner is before this court seeking for the following news. The list raised by the petitioner has already been dealt by a coordinate bench of this court in its order date 4 July 2023, WP number 18907 of 2017. In that view of the matter, the BBMP having taken a policy decision to stop issuing licenses for displaying advertisement in commercial holdings in the city of Bangalore. In terms of the direction issued by the division bench of this court, nothing survives for consideration in the present matter. The petition stands dismissed.
Great.
Raju. Muniraju. But order 3/11/2023, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Ravi Shankar. Okay. Nagarajappa, Naveen. Nagarajappa is directed to accept notice for respondent number 3. This is direct delete the name of Sri A. Ravishankar as that appearing for respondent number 3. Counsel for the petition itself. 2 sets of the petition along with annexures on the said counsel. Objections, if any, by 4th January, relist on 9th January.
There was the previous session, there was on page number
86.
23 minutes.
Page
20, 22 minutes.
22 as a plan. Yes.
Soon after the plan minutes, in 1993, which the lordships will find at page 23 minutes.
Even if CMC were to approve, they have to approve by following the regulations. Which regulations are they?
It has to be under the KTCP Act along with the civic communities and all that. I've actually thought over that once, and I was trying to understand the ground scenario. In Chikbalapur. This is not just one instance for this. There are several other layouts, and I've got those documents of the where it is similar, where there are sites, no civic communities, but there are roads. I can point that out.
There are no civic communities, there are no parks, the road is 20 feet, 15 feet. Is that a road measurement at all?
Because I do know this, I will not brought this up, and it's not right in my heart. I was hesitant to make this submission, but also, your lordships will see in the same village, very neighboring site, where page 1 minutes. In 1992, plan is approved by the Municipal Council. Thereafter, we grant them in e-khata as well. This is where layout plan is. And thereafter, the e-khatas which are basically issued. In fact, I have another document which shows that the land is not even converted. But sanction plan is awarded e-khatas which is delivered.
CMC, what is
CMC now?
My lords have raised it on several occasions. But with regard to the government, from 2007, we have brought out circulars.
This is 92 and 95.
My lords, understood, my lords. What has happened in this is 1986, there was a direction by the Director of Municipal Administration. Then, after several.
Let him complete his section. Yes. Anything else?
It's page 23 minutes, just for a moment. Manual khata is given. Then, after your lordship.
By the CMC.
Yes, by the CMC.
Co-conspirator or co-accused.
Yes, page number 52 thereafter. At page 52 minutes, there is something called as the Municipal Administrative Authority Records. They classified as MAR 19. Now, this is way back in the year 1995. I just want to draw your attention to Annexure L at page 55 minutes. Not 55 minutes. That circular minute would be at page 40 to 43 minutes. This is this circular minutes. That I make my application to grant the e-khata minutes.
This is for issuance of e-khata.
Please, now
making mandatory for e-khata.
If I can invite a lordship attention to paragraph 2 minutes. It says that ಈಗಾಗಲೇ ನಿರ್ಮಲ ನಗರ ಕರ್ನಾಟಕ ಪೌರ ಸುಧಾರಣೆ ಯೋಜನೆಯಡಿ ಸರ್ವೆ ಮಾಡಿದ ಆಸ್ತಿಗಳ ಮಾಹಿತಿಗಳು ಕೂಡ ಈ ಆಸ್ತಿ ತಂತ್ರಾಂಶದಲ್ಲಿ ಲಭ್ಯವಾಗುತ್ತಿದೆ. ಅಸ್ತಿನ ಸರ್ವೆ ಸಮಯದಲ್ಲಿ MR 19 ದಾಖಲೆಯಲ್ಲಿ ಲಭ್ಯವಿದ್ದ ಆಸ್ತಿಗಳನ್ನು ಅಧಿಕೃತ ಆಸ್ತಿಗಳೆಂದು ಪರಿಗಣಿಸಲಾಗಿದೆ. So at page 55 minutes, I've showed you that I've been issued the MAR 19 minutes way back in 1993, 1995 itself. So now in 2017, when I make that application, reject it, my lords. Thereafter, the joint director rejects it, so the municipal council backs in my favor and says that they have issued the sanction.
They'll have to bat in your favor only, not they have to bat in their favor.
All the water is flown under the bridge, right? So now this puts me into some difficulty in which again.
As of 2020 also we have filed a photo that there will be no development. Take serious and by number. My lords may kindly take to page 8 of our objection statement.
8 of the objections.
Of filed on 2019. 20th of February 2019. But the seal is 12th March 2019. We'll read out the circular. This was issued on 22 March 2017. ರಾಜ್ಯದಲ್ಲಿನ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಕಾಯ್ದೆಯನ್ನು ವಿಸ್ತರಿಸದೆ ಇರುವ ಪ್ರದೇಶಗಳ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯನ್ನು ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆಯಿಂದ ಪಡೆಯಲು ಉಲ್ಲೇಖ 173 ಪತ್ರ ಸುತ್ತೋಲೆಗಳಲ್ಲಿ ಸರ್ಕಾರದ ನಿರ್ದೇಶನಗಳಿರುತ್ತದೆ. ಆದಾಗೂ ಇಂತಹ ಕ್ಷೇತ್ರದಲ್ಲಿ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆಯ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಹಲವಾರು ಅನಧಿಕೃತ ಬಡಾವಣೆಗಳು ನಗರ ಪ್ರದೇಶಗಳಲ್ಲಿ ರಚಿತಗೊಂಡು ಇಂತಹ ವಿನ್ಯಾಸಗಳಿಗೆ ಅಗತ್ಯವಿರುವ ಅನುಮೋದನೆಗಳನ್ನು ಪಡೆಯುವ ಪೂರ್ವದಲ್ಲಿಯೇ ನಿವೇಶನಗಳಿಗೆ ಖಾತೆಗಳನ್ನು ನೀಡುವ ಕ್ರಮವನ್ನು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. ನಗರ ಪ್ರದೇಶಗಳಲ್ಲಿ ಪರಿವರ್ತಿಸಿದ ಜಮೀನುಗಳಿಗೆ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಅನಧಿಕೃತ ಬಡಾವಣೆ ರೆವಿನ್ಯೂ ಬಡಾವಣೆಗಳನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿ ನಿವೇಶನಗಳನ್ನು ನೋಂದಣಿ ಮಾಡಿಕೊಂಡು ಕಟ್ಟಡಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ನಿರ್ಮಿಸುವುದರಿಂದ ಆಗುವ ಪ್ರತಿಕೂಲ ಪರಿಣಾಮಗಳನ್ನು ಗಮನಿಸಲಾಗಿ ನಗರ ಪ್ರದೇಶಗಳಲ್ಲಿ ಉದ್ಯಾನವನ ಬಯಲು ಜಾಗಗಳ ಕೊರತೆ, ನಾಗರಿಕ ಸೌಲಭ್ಯಗಳು ಕಲ್ಪಿಸುವಲ್ಲಿ ವಿಫಲತೆ, ವ್ಯವಸ್ಥಿತವಾದ ರಸ್ತೆಯು ಪರಿಚಲನೆ, ಮೂಲಭೂತ ಸೌಕರ್ಯದ ಕೊರತೆ ಹಾಗೂ ಯೋಜಿತ ಬೆಳವಣಿಗೆಗಳಲ್ಲಿ ತೊಡಗುಗಳಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಇಂತಹ ಬೆಳವಣಿಗೆಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸದೆ ಅಭಿವೃದ್ಧಿ ಬೆಳವಣಿಗೆಗಳಲ್ಲಿ ಪಾರದರ್ಶಕತೆ, ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿ ಹಾಗೂ ನಾಗರಿಕ ಸ್ನೇಹಿ ಸುಧಾರಣೆಗಳನ್ನು ತರಲು ಸರ್ಕಾರದ ಹಂತದಲ್ಲಿ ಕಾಯ್ದೆಗಳನ್ನು ತಿದ್ದುಪಡಿ, ಆಡಳಿತ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಸುಧಾರಣೆಗಳನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಇದಕ್ಕೆ ಪೂರಕವಾಗುವಂತೆ ವಿನ್ಯಾಸಗಳಿಗೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಗಳಿಂದ ಅನುಮೋದನೆ ಪಡೆಯದೆ ನಿವೇಶನಗಳನ್ನು ರಚಿಸಿ ಪರಭಾರ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ತಡೆಯುವ ಅವಶ್ಯಕತೆಯಿರುತ್ತದೆ ಹಾಗೂ ದಿನಾಂಕ 19/10/2013 ಮುಂಚಿತವಾಗಿ ಬಂದಿರುವ ಅನಧಿಕೃತ ಬೆಳವಣಿಗೆಗಳನ್ನು ಸಕ್ರಮಗೊಳಿಸುವ ಕುರಿತು ಉಲ್ಲೇಖ 4/6 ಅಧಿಸೂಚನೆಯಲ್ಲಿ ನಿಯಮಗಳನ್ನು ರಚಿಸಲಾಗಿದ್ದು ಜಾರಿಗೊಳಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಹಾಗಾಗಿ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಇನ್ನು ಮುಂದೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಗಳಿಂದ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಇರುವ ನಿವೇಶನಗಳಿಗೆ ಖಾತೆಯನ್ನು ನೀಡಬಾರದೆಂದು ಕಟ್ಟುನಿಟ್ಟಿನ ಸೂಚನೆ ನೀಡಲಾಗಿದೆ. ಇಂತಹ ಕ್ರಮ ಕೈಗೊಳ್ಳದೆ ಖಾತೆಗಳನ್ನು ವಿತರಿಸಿದಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯ ಆಯುಕ್ತರು, ಪೌರಾಯುಕ್ತರು, ಮುಖ್ಯಾಧಿಕಾರಿಗಳನ್ನು ನೇರ ಹೊಣೆಗಾರನಾಗಿ ಮಾಡಿ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು.
ಇನ್ನು ಮುಂದೆ ಸಕ್ರಮ for the older ones.
My lord, the court at the relevant point wanted to know whether the layout has been developed. So we have also produced photographs along with our additional statement of objections that may be kindly looked into. 13/2/2020, my lords, additional statement.
I'm sorry to interject, but this notification of an is withdrawn. Any case, I mean, it doesn't apply to you, it is very different. Page 14 is the photographs. This is not a case where the layout has been developed and sites have been formed and conveyance has been done. The petitioner still owns the entire extent of the sites matter. Page 14 and 15. This is the state of the land matter. This has not been disputed by the petitioner.
Last on?
This is as on filing date was on 13/2/2020.
When is this photographs?
Worst case scenario, at least after filing of the petition.
Which I'll learn.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಗೌರ್ಮೆಂಟ್ ವಾಂಟ್ ಬಿ ಪ್ರಿಪೇರ್ಡ್ ಟು ದಟ್ ನೆಕ್ಸ್ಟ್
ಹಳೇದು ಯಾವ್ದೋ ಪಿಕ್ಚರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ? We developed it, have been sites and any construction.
One is 30 sites have been sold. I produced additional documents, which is IA number 3 of 2021.
3 of 21.
Yes.
Yes.
So, we'll see minutes. At page 15 minutes. But these are the same deeds where I have made over about 30 sites minutes to 2 people minutes.
Only 2 people.
That is the correct position. That's
Hemavati and GH Nagaraj.
Yes. So the remaining 69 sites minutes.
How are they related to you?
These minutes.
How are they related to you?
That I don't know. I don't think they're related to me. That is the first point. Now, my development is also raised something very interesting, saying that the roads are not formed, there are no planes. Now, if I can just invite you to take a look back 2 minutes, the document which is basically which evidences that Tata was.
I thought you had finished your again. You thought you had finished your argument. He is complete.
Okay, so
No, my lords, with regard to the implementation of KTCP Act, there are 3 provisions. 17 is the power to issue plan.
Yes.
Section 17 of KTCP Act. My lords, sanction for single plot or subdivision of plot or layout of private street. The state government shall by rules prescribe the standards to be followed in minimum extent of land to be considered for approval of layout for subdividing a plot and prescribe the minimum extent of area to be earmarked for park, open spaces and civic community sites and laying out roads. Every person who intends to develop a single plot or subdivide this plot by making a layout on or after the date of the publication of the declaration of local planning area under section 4A shall submit detailed plan of the layout of his plot, showing layout of roads, subdivided plots and earmarking area for park and open spaces and civic communities to such extent and in such manner as prescribed. Because it is a local planning authority, they are the people who have to do it. Then I'll just take to the subsection 2 and go to section 76. The planning authority may within the prescribed period sanction such plan either without modification or subject to such modification. This can over kindly look at it.
26, which one?
Of KTCP Act.
76.
76 M.
M. Overriding.
Effect of other laws. Sale are provided in this Act. The provisions of this Act and the rules, regulations, and bylaws made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any other law. So this is the overriding effect of this Act.
Yes.
So there was one more practical difficulty. What had happened, my lords? In some areas there was no local planning authority. So section 387 of Karnataka Municipal Corporation Act 1964 was brought into effect, my lords. My lordships may kindly take to that.
Now what is the status? The planning area Planning
My lord,
authorities are
where
there
there
across
is
the
no
state.
planning authority, nearest planning authority derives the jurisdiction. That's the reason why the amendment.
Now,
was
what
put
is
in.
the status?
My lord?
Planning authority is established.
Now,
for-
what has happened is, when the TMC issued the plan, they were under the Kolar district.
Today,
Today, Chikbalapur planning authority is there.
across the state.
Across the state, most of the districts have their own planning authority.
So
Or if there is a vacuum, my lords, 387 comes into play.
nearest.
387 of Karnataka Municipality Act 1964. Seven was an amendment made which has effect from 8th December 1976. So 387 reads consultation with planning authority. The municipal council, as it controls the municipal council, the state brought the amendment law. The municipal council shall, in places where the planning authority has not been constituted under the Karnataka Town and Country Planning Act, consult the nearest planning authority in matters affecting town planning.
Consult.
My lords?
Consult.
Consult, coordinate bench, consult would also confer the power.
Consult ಅಂದ್ರೆ concur.
Consult is at
approval.
least let them have an idea with regard to the basic community roads, whatever needed to be. It was an expert body, my lords.
We are proposing to issue a plan sanction.
At least if that had been done, some.
As regards plan sanction, like town planning, it's very broad.
Then section 2 of the Karnataka Town and Country Planning Act describes water development is, my lord. Section 2 very specifically says even subdivision is a development.
Town planning. Matters affecting town planning. It could be anything. Matters affecting town planning is.
If my lords were to read 76M and also 387, it is the town planning authority or the nearest town planning authority. We have also produced document to show before 2017 it was Kolar district which had a town planning authority. Post 2017 Chikbalapur was created and it has its own town planning authority. So coordinate bench decision is also there. If my lords permits, I'll pass it over.
Yes.
Page 9 talks about the applicability of section 387.
Yes.
Para 10, my lords, it is not in dispute that the Kata of subject property stood in the name of father of the second petitioner for long years. It is also not in dispute that the deceased father had got the land converted from agriculture to non-agricultural purpose. Therefore, in the case at hand, Kata stood in the name of the earlier Katadar and the land is converted from agriculture to non-agricultural purpose. In the normal circumstance, Kata could have been issued to the subject property or any development in the said property after consulting planning authority by the municipal council in terms of section 387. Section 387 of the 1964 Act reads as consultation with planning authority. The municipal council shall, in places where the planning authority has not been constituted under the Karnataka Town and Country Planning Act, consult the nearest planning authority in matters affecting town. After consulting, my lords had raised the same thing. What
what they could have, it has a very wider meaning. But in the present case, that no such communication has been sent to the nearest planning authorities.
There's no consultation at all.
No consultation.
Without consultation, without satisfying 387,
And one more important.
no plan sanction could be given
Yes,
by the
ma'am.
CMC.
In the DC sort of conversion, I just missed the aspect. Just read out the subclause 5 is relevant. Subclause 5 very specifically says whatever subdivision, including layout, you have to go and take the layout plan from the Naksha.
Yes.
So DC order was very much clear. So they were aware what they had to do. Conversion is a precursor to subdividing the plot. When the conversion order itself is condition and it is unambiguous, my lordship. This is not the case where there is ambiguity or there is no such clause, but interpretation of the sections will come into play. Here the DC in its senses felt that these are the conditions I am going to impose. They have accepted, they have not challenged the same. And subclause 5 of the conversion order very clearly says that you have to take the plan from this particular authority itself. What made them not comply with the condition is at their own peril.
You are appearing for the CMC.
Yeah.
The main player.
That point of time, there was certain circular was there, otherwise the municipality to approve it. As per annexure E, we have taken a decision this Friday after resolution. Recently, Kata is name under certain conditions of that. The plan responding.
Irregularity when 387 is there. Have you consulted the planning authority?
Consultation.
And how did you sanction this plan?
So there is no actual sanction of the plan under the exercising power under the act. Not the resolution. There is therefore by the resolution. So resolution is available in annexation E. As per the decision, pay certain amount, government charges, and
on what basis are you collecting those amounts? On what basis are you collecting those amounts? How are you empowered to collect those amounts? Register the kata in respect to each of the plots or the land? So subdivision of plots. What is your authority to subdivide a plot?
Yeah.
And how do you collect the tax?
At that point of time, circular was there. The planning authority.
Circular cannot override the law.
Because the planning, I cannot say plan was sanctioned under the plan. There was some irregularity. But as on today, irregularity has happened. Same time, the property is not sold. Still, let him apply to the.
So far as this case, thankfully, it is still with the petitioner.
Yes.
But insofar as so many other cases, depending on your seal on the plan, your resolution reflected in the plan, copy of the resolution being furnished, kata certificate issued by you, people are buying this. They are investing all their money here, hard-earned money, loan, savings. And you say it is only irregularity.
That happened in 1990.
It is not an irregularity, it is a violation of law.
That happened in 1990.
ಆಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು demolition. B kata, we won't issue A kata because it's not a regular plan sanction, we'll issue B kata. And no plan sanction. So you collect money from everybody. Sub-registrar for registration, plan sanction, development fee, kata fee, tax, plan sanction for that house afterwards. The government only collecting monies. Duty. Whereas self-government, there's no other duty. Hacking ಮಾಡ್ತೀರಾ ನೀವು. Create all the problems. What is the stand of the state in respect of what they've done? What is the stand of the state as to what CMC has done? What is the action for CMC?
We not followed the circulars even many have been mentioned. If the court takes cognizance.
What cognizance have you taken?
There's nothing on record for me to show that any cognizance.
Not for the court to take, it is for you to take. You start taking your action, this won't come up to the court.
Observation comes into the effect, it will facilitate us to instruction.
You should fairly come forward and say we are taking action. A matter will deal with it. Idralli ಏನ್ ಮಾಡ್ತೀರಿ? Not a stray case, so many of these things.
Let's interstep fired in a BDMP matter when the lodge instructed the sub-judicial office to order notice so that they see the plan and sell the flags as such. Here the integration is made with the planning authority and ultimately conveyance only gives the unlawful gains as such. It should be stemmed at the sub-judicial level, wherein they should insist that they should have a coordination with the planning authority and they should insist on a plan for them to register. So stops a third party creation of right and also unlawful monetary.
Who is to
gains.
issue that? Not for the court, it's for the state.
My lord,
The court cannot get into administration. As it is, courts are being blamed for it. You are not doing your job.
the court feels because though there are circulars, directions, interpretation of laws of the.
Let us put you in the spot. What do you feel?
At this side of the bench, my lords, my hands are restricted, my lords.
Take action, Mr. Chandrasekhar. How many times do you want the court to take action? We'll take.
This is one more aspect. If my lords take the cognizance, then do the new thing. And some more, my lords, another 3 pages of the decision might be relevant. Because in a Bayappa matter which went to the Supreme Court, the Supreme Court observed that KTCP Act has an overriding effect over any other act. If my lord wants, I'll take to the relevant act. That's there. So unequivocally it said that
Only the distinction drawn was between KTCP and KDV because they came in at the same time and both of them were special enactment. Otherwise, for all municipal purposes, KTCP overrides.
KTCP is a self-contained act when it comes to subdivision development. It defines what is the planning authority. Override is effect 76M as held by Supreme Court in the Bayappa case. That is the surmise of the.
So reserve. Yes, please. You are going to suffer, so you are entitled to make all the submissions.
Now,
Yes.
Basically, second point is, I've also relinquished the land in favor of the newspapers.
You executed a relinquishment deed?
Please, the authority there. But if I can just read it out minutes from the third line. I will buy the car of 76,000 pence.
these numbers way back in 1993. When the receiving number shows ರಲ್ಲಿ ಅಭಿವೃದ್ಧಿ ಶುಲ್ಕವನ್ನು ಪುರಸಭೆ ಪಾವತಿಸಿದ್ದು ಈ ಲೇಔಟ್ ನಲ್ಲಿ ಬರುವ ರಸ್ತೆ ಚರಂಡಿ ಎಲ್ಲ ಹಕ್ಕುಗಳನ್ನು ಪುರಸಭೆ ಉಳಿಸಿಕೊಂಡು ಸಭೆಯ ಎಲ್ಲ ಶುಲ್ಕವನ್ನು ಅರ್ಜಿದಾರರು ಶ್ರೀ ಧರ್ಮಗೋಪಾಲ್ ಅವರಿಗೆ ಪಾವತಿಸಿ ಶರತಿಸಿ ಸೋರಿಸು. Again, there was section
170 of the municipalities.
Yes. The question said, all of the municipal council get any power to basically issue a sanction plan. 171 minutes. They can issue a sanction. Also have 175 minutes. 170 is the first time. I need to make it out my laws to be from this. Why the applicant? See. So I give them money to basically develop everything that is not done. I log on minutes that maybe I should have enforced this right. You can also see one. Now, as in the event I wish to develop whatever was there inside the layout of this, then the obligation starts to move. Just tell me that I have not done it.
So no problem about it. See, what is being submitted is if they were to sanction, they have to consult in terms of 387.
Yes.
And it has to be done as per the regulations applicable.
Yes.
The sanction has been done without consulting, without applying regulation. It is not in terms of the requirement of the notification of 50%, 55% and 45%. Civic amenities of 15%, parks and open space of 15% has not been designated. Roads of the balance 30% has not been done. Everything has been made into site with 15 feet and 20 feet road. The entire plan sanction is not in accordance with the applicable law.
That makes, I don't dispute that it's all that's following up, that is correct. I don't know, I cannot dispute. But the workshops, I do not know from where my lawyer counsel gets anything to say that the consultation on the day.
He's trying to defend himself now.
No, that will be the case when the offer to become affidavit. They have not done it in the last. It's a resolution. So my understanding to be that they have consulted the authorities. The time they have the discipline.
Can you say that you don't know what the regulations applicable for a layout plan are? And whether this, you submitted a plan? Then also the regulations were applicable. You were required to make the plan in terms of the applicable regulations and then submit it for approval. You did not do it in that way. You did not do it that way. Not when you have violated yourself. Other layouts, they will take action. Yes.
This is the ground reality. So
You are the starting point. You are the starting point. We'll have the others also. We'll have the others.
The passage of time, nothing happens that I do.
You cannot say that you were very good and you have followed the law. The plan was submitted by you. Not in accordance with it. Why should it not be that both of you are polluted?
2018-19 was understanding. Plan was sanctioned, pollution, I will understand this. 1993, Kata is giving pollution, I will understand it. Again, is giving, even then it will verify spreadsheet, but I found out and say maybe pollution. 2017, 18, 19, it's a lot of verification.
All that they have done is to safeguard their actions. The cover up of their actions. They're only covering up their action from the beginning. I understand. we can't say we understand, but we like, if these kind of things are permitted to be done by the CMC in violation of everything, layouts will come about all over the place without any orderly development. It will go against the object of KDCP.
I paid those taxes. I paid everything. These are the sites that have been designated for the development has to be given about 77,000.
All that will direct them to return bill.
I usually all the money that I spent was your own.
All that will be directed to be returned with commercial rate of interest.
Property is still applying to the planning level. Whatever method as per the.
That he always can do. That he always can do. But what do we do with you? With the suddari of all these things, because you are the one who is sanctioned. On plots sanctioned by you.
According to me, yes, we have not.
Do you want to persist with that submission? That legal or illegal, you are entitled to collect tax. And then the illegality is based on your own action.
Yes.
Who has authorized it?
We have only development charges and that cannot be not traceable to the government country planning act. That sanction.
Exactly, that is the submission made by the AAG. It is not traceable, but you seem to trace it.
Treating it as not lot.
We need the state's submission as to what the state stand on this. Against them and
as per the circular, we are told that if such a thing happens, we are going
this
to.
particular case, what is the state stand? You know, put it on an affidavit. So what is
15
the
days time, my lord, I shall take instruction. In the meantime, when it is resolved, we'll put it on.
only for that purpose you file that? But so this one. The AGA. Expert is granted 15 days time.
That's 20 days, my lord. Substantive.
20 days, bada late ago.
15 days.
15 days. Like 20 days.
Because it affects the entire state of
Karnataka. We'll fix it. That Council for Land AGA seeks for and is granted 20 days time to file the affidavit of the whose affidavit will you file?
Principal Secretary, you give your Director Municipal Administration.
Of the Director Municipal Administration. Facing the stand of the state in respect of the actions taken by respondent number 3, as also the situation that the petitioner has been put in view of such actions. Affidavit to be filed on or before 13th December. Released on 15th December. Nothing, we are not going to hear both of you. It's only for the affidavit. You go peacefully and get married.
Last one,
We'll deal with that. If you want to file any written submission, file that for your satisfaction.
For the hearing 2:30.
2:30 for the hearing.
Yes, sir. Okay, sir.
Bhargav? Court fee has been paid? What we objection is?
Close to the respondent.
Ah.
Marriage is there on 27, 28,
Yes.
After David was yesterday, I paid 24 lakhs.
5 lakhs is pending and
No, sir. But as on 21/6/2013, for annexure F, page 21, the total dues is 86,09,292.
18% interest on it.
But after issuance of this notice, the petitioner has deposited 41 lakhs as per my instructions that I received. The outstanding dues are still about 34 to 35 lakhs. In fact, the
45 lakhs. 86, 41 and
41 lakhs. For 45.
40.
Apart from this minute, I have been instructed that minute there is one more payment of 10 lakhs. But as of now, the total dues minute position is 31,64,285. But in fact, the land mandap was closed on 17th of this month. That the people who have booked this hall for the functions, they approached the district commissioner, Mysore district, saying that we have booked the hall for functions, and if it is closed, we can't perform our function. Considering the request of the people, that it was reopened once again. That it is not closed as of now, it is open. But my instructions are that the outstanding dues if since 2023 January,
The
they have to
marriage
pay
season, the order of marriage would be fixed. What we'll do
they
is,
have to pay the money. That's what.
whoever is booked, their payment will be made directly to you and not to them until this amounts are recovered.
Lakhs is fine. The rate of 18%.
Penalty ಹಾಕಿಲ್ಲ ಸದ್ಯಕ್ಕೆ. Or double the penalty ಹಾಕ್ತಾರೆ.
No, my instructions are that minute for the period during which they could not perform any functions during Corona. There is a waiver of about 70 lakhs. A resolution has been passed by the board for a period of approximately 1.5 years. It has been waived. Therefore, submission that they have suffered last during the COVID.
Whatever you are receiving from your people who booked your convention or will be paid directly to them.
Let us not get into that. Let the petitioner directly pay it to us. Otherwise, we will have to get the accounts and other things, and what would be the expense.
How much do you charge for each function? Approximately. Right? 1 lakh per function, you will pay them 50,000 for your expenses. ಅದಕ್ಕೆ 50. Expenses ni 50,000 ಇಟ್ಕೊಳ್ಳಿ, 1 lakh ಕೊಡ್ತಾ ಹೋಗಿ.
The outstanding dues, let them pay it in an installment. If you last may kindly fix the installment itself. Not asking them to pay 1 lakh.
Mr. Vivekananda is more reasonable than us.
The reason
Yen installments it.
Installments on 4 installments could be. Fresh calculations could be 18% interest.
that we can't do.
That is as per the statute. The statute that cannot be changed. Statute tell you DBMP Act only double is penalty twice plus 2%, 24%. So this 31 lakhs.
Clause 16 of the is provide for imposition of 18% interest. That we have not calculated that.
So 31 lakhs you will pay in how many installments? 4 installments. That is of around 8.5 lakhs, 9 lakhs. 8.5 lakhs, 8.5 lakhs monthly installments.
That was installment. Then again, it would not carry interest.
Mr. Gopal Swami, the more you delay, the interest will be mounting on you at 18%. 1 month installment ಕೊಟ್ಬಿಟ್ರೆ interest ಇಲ್ಲ ಅಂತಲ್ಲ. Tomorrow if you pay 9 lakhs, EMI. You will have to, if you want to reduce your interest, you have to pay it early. Really, you think about it itself. Another thing now, tax sale, we used to file writ petition, but say don't grant stay.
5 equal installments.
5 equal installments of
Fortnight, every fortnight.
Fortnight.
5 months.
ಮುಖ್ಯ ಆಗೋದಿಲ್ಲ, ಕಲ್ಯಾಣ ಮಂಟಪ every fortnight pay ಮಾಡ್ತಾರೆ.
1 month. ಇವಾಗ 15 ದಿನ ಮಾತ್ರ ಇರೋದು, ಅದಾದ್ಮೇಲೆ 1 ತಿಂಗಳು ಇಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಶುರು ಆಗತ್ತೆ ಮತ್ತೆ.
At least show their bona fides, not by paying at least 10 lakhs. ಅದಕ್ಕೆ ಕಡಿಮೆ ಆಗಿರೋದು, ಟೋಟಲ್ ಅಮೌಂಟ್ ಕಡಿಮೆ ಆಗಿರೋದು ಅದರಿಂದ.
The matter is moved today. Attending that the respondents have directed the petitioner to close the Kalyan Mandap being operated by the petitioner on account of non-payment rentals in relation that rental right, not tax.
No, not tax, rental.
It's a lease.
For 5 years.
Then 18% is too.
The annual rent.
Tax and we can't do
The
anything.
annual rent is not 36 lakhs for the entire whole of the year. It is very reasonable, not 36 lakhs for a Kalyan Mandap of 18,000 square feet of not the constructed area.
We give this, think about what
Yes.
if you can do something. That Sri Gopal Swami, the senior counsel appearing for the petitioner, but that due to financial stringency, the rentals could not be paid. But however, undertakes that all the balance amount which is due of roughly 32 lakhs, along with
Whatever the amount due, 32 lakhs.
approximately 32 lakhs in that. Thereon will be paid within 5 months from today in equal installments. 18% of 5 months andre on 31. Another 6 lakhs or 2 lakhs. Submit that every month a sum of rupees 8 lakhs would be paid. The balance adjustable in the last month. The submission is placed on record. An affidavit to be filed by the petitioner on or before ಬೆಂಗಳೂರಲ್ಲಿ ಇಲ್ವಾ ಅವರು? ಇಲ್ಲೇ ಪಕ್ಕದಲ್ಲಿ BTM ಲೇಔಟ್ ಬೆಂಗಳೂರು. ರಾಂಗ್ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಪೆಟಿಷನ್? Affidavit to be filed on or before 29th November 2023. In view of the said submission, the respondents are directed to, in view of the said undertaking, respondents are permitted to allow the petitioner to operate the Kalyan Mandap, taking into consideration that various third parties have already booked it for their weddings. If the Kalyan Mandap is closed, those persons will be unnecessarily and adversely affected due to the default of the petition. The representation for the other.
If there is any default in making a payment, we may permit it to take. Otherwise, every month,
If there is any default committed, respondent has liberty to move this court. Sri Vivekananda accepts notice for respondent. Contract, Mr. Gopal, we can't make a contract between both of you. You agreed. You have agreed to your contract. If you don't want to go ahead with contract, give up the contract. They'll give it to somebody else.
Payment next year.
Even 7th or 1st of December. I don't know.
Why has this been moved?
It was moved because there was a direction by the Honorable Court not to interfere with the possession of the petition. He was running a bakery. The permission was given for running a bakery. Then he had converted it into a hotel. We have
This is, we had given another date.
date.
Why is it
Mistake it is yes.
December,
Okay. Let it
released on 1st December. Objections to IS 7? No objection idea ilwa?
Some office of
No
the
objection.
there are some office objections with regard to the
One by one we'll deal.
Yes.
Now 7 of 23, no serious objection. A 7 of 23 has been filed for condition delay in the written statement filed by respondent number one. There's no serious objection to said application. Accepting the reasons stated in support of IS 7 of 23, the delay in filing the written statement is condoned, subject to payment of cost of good cost. You will have to say
agree with your lordship.
5 numbers, 6 numbers.
3 numbers will be.
These are the matters where the benevolent fund will get some money. Leave it to you, Mr. Usman. Give us a nice figure. Whatever you say, we'll put it. Please remember that. We won't. We are not negotiating. Give a good number.
Maybe 1,000. Let it be 5,000.
I rejected.
I leave it to your lordship then.
Subject to payment of cost of rupees 25,000 to the advocates benevolent clerks benevolent fund. We don't impose here.
Yes,
We can't impose anywhere. Certification of office objection on written statement filed by
There are some office objections.
copies. Counsel for respondent number 1 seeks bond is granted 2 weeks time.
Yes.
To comply with the office objection raised on a written statement. A2 of 23. If you have to file objections. No objection allowed. So you have to file.
No,
objections. Sorry.
I have to file objection.
You have to file
yes.
objection.
No, that has to be taken up, my lord, at the time of trial only.
File your objection.
Yeah, I will file my objection, my lord. 2 weeks time.
It not be on that ground.
Yes.
Counsel for respondent number 1 seeks bond is granted 2 weeks time to file his objections to IA2 of 23. IA5 of 23 objection hakidira, objection filed.
They have, that has to be heard.
What is IA1 of 23?
That is for some direction.
What directions?
All, my lord, with regard to at the time of the trial, my lord.
No, what is this direction?
That
Income
is
tax
all for
department.
certain documents. That also I'll file objections, my lord.
You have not filed objection.
No, I have not filed objection, I'll file.
IA2 of 23 and IA1 of 20, 1 of 23 and 2 of 23, 2 weeks time. Released on 18th December. Counsel for the petitioner released on 15th December. Interim order earlier granted is extended next. Where are you? What happened in settlement? Settlement ಕರ್ಕೊಂಡು ಬರ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲಪ್ಪ ವಿಜಯ್ ಕುಮಾರ್ ರೆಡ್ಡಿ is already entered appearance. Yes. Oh, you have to list on They have changed the list. With settlement,
Settlement has happened.
Give us a document.
Against FNW issue, it is that those are the compromise that happened. You don't complain with the terms of the.
Yes.
After the right application and
Yes.
is challenging that order that have come in.
Yes.
Only
Yes. Yes.
Part of the amount, fees have been paid at second, but that was not disclosed.
So 3 crore 50 lakhs you have to pay. How much are you paying now? How much are you going to deposit now? 3 crore 50 you'll deposit. Part of the 50 lakhs and all is not. Your 3 crore 50 lakhs is due.
3 crore lakhs is not due. Due. In 20 is the joint withdrawal.
20.
Till December of 2023.
$34 23 you paid 50 lakhs. With a document for that.
The next time you pay 28.
28.
If you go to mirror,
30 lakhs on
30 lakhs mirror on
December.
it's 29. Basics mirror other 50 lakhs. It has been.
These 50 lakhs.
Other 3, 7, 3, 7, 50 lakhs. 30 lakhs has been in cash payment.
What happened to 34, 35 and 36? 34 and 35. So you are due now of till now you are due. Bari 50 lakhs bitre baki ella due. One crore 30 lakhs bitre 3 crore 50. Adral 50 bitre 3. ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ 50 ಲಕ್ಷ ಎಲ್ಲ ಆಗಲ್ಲ ಒಂದೂವರೆ ಕೊಡಂಗಿದ್ರೆ will stay, otherwise you go inside. On this basis the settlement is being done. Yes. NBW will stay. FLW will continue if you don't pay the money. Mislead people to enter into ಅದಕ್ಕೆ ಅದಾಕಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇಲ್ಲ 138. ಎಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಾ? 1 crore by this month and 4 weeks.
4 weeks.
Correct ಆಗಿ ಹೇಳ್ಬಿಡಿ. By 14th you pay. By 15th. We'll restrict on 19th. But also for the petitioner undertakes to make payment or deposit a sum of rupees 1 crore with this court.
I didn't pay.
Pay a sum of rupees, but to the will undertakes to make payment of the sum of rupees 1 crore to the respondent by 15th December. That year of the matter, the order dated 3/10/2023 passed by the 13th Additional Chief Metropolitan Magistrate in C number 55066 of 2018. It till next day, we list on 19th December. Needless to say, if the aforesaid payment is not made by that date, the interim order will stand automatically vacated. Issue notice to the respondent, process fee, copies to be furnished by end of day 27. Counsel for the petitioner is also permitted. So the counsel for respondent before the trial court. No office objection to the contract. Mr. Dhanande?
Yes.
Request of counsel for the petitioner relist on 15th December. Ramnagar ನೀವೇ ಅಲ್ಲ Yes, Soumyaji, who has entered affairs for respond number 2, also undertakes to appear for respond number 3, registry direct print his name as such. Yes. Both respond private party, na? Both to PDO. ಅದು ನೀವೇ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಗಂಗಯ್ಯ representing the EO and CEO. Mr. Channagangaya, ಇದರ ಪ್ಯಾನೆಲ್ ಮಾಗಡಿ ತಾಲೂಕು ರಾಮನಗರ ಯಾರಿದ್ದಾರೆ ಇವಾಗ ನಿಮ್ದು ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಆಗತ್ತಾ ಯು ಕ್ಯಾನ್ ಅಪಿಯರ್ we'll direct you to take notice, you file your work. It is submitted that Shri G.H. Channa Gangaya is no longer in panel of respond number 4. Then Shri B.J. Soumyaji, who is on the panel of respond number 4, is directed to accept notice. The copy cuts back over here. Third one. Argument ಮಾಡ್ತೀರಾ? B.J. Soumyaji seeks and is granted 2 weeks time to obtain instruction, make his submission. ಇವತ್ತು we have issued notice. Let him get date fix ಮಾಡ್ತೀವಿ ಎಲ್ಲಾದ್ರಲ್ಲೂ fix. Previous time 15th December.
They say we will take from 2008. If you have located.
OC ಯಾವಾಗ
Proceed 24. If I go to 2000,
you take the OC.
yes, that is what is our case.
The date of the document, but with effect from 2008.
2008.
How can you give with effect?
Because
Sanction, plan sanction ಯಾವತ್ತು?
plan sanction 2006.
2006.
And the completion certificate is issued in 2011 with effect from 2008.
Why did you issue it in 2000?
Upon inspection.
When was the application made?
Application was made in 2010.
10.
2010.
Yes. What made 2/12/2010? And it was issued on
25/4/2009.
Next year, June.
Was it occupied before that date?
It was not occupied.
Then why are they to pay taxes?
It was not occupied in the sense that the building license was issued in 2006. Thereafter, my lord, they have undertaken construction, and our stand is that by 17/1/2008, with respect to building, my lord, it is completed. I mean, in all respects, that is our stand.
Was it occupied?
No, it was not, my lord, may I submit, my lord? This writ petition, my lord, was in fact challenging earlier round of litigation, my lord. Annexure P was challenged. Annexure P of this writ petition was challenged, which was a demand notice for payment of tax. Lord, by virtue of annexure R, my lord, this honorable court directed the corporation to consider the representation at annexure P, and we considered and we passed annexure A. Now, my lord, the writ petition is filed. My lord, in the prayer, Rakshak may kindly come to prayer. A column B. Issue a writ of mandamus directing the respondents to consider the representation dated 27/12/2013. Lord, if the impugned annexure is seen, annexure A, you have considered, my lord, first, Lord,
But
now
if
the issue is
his submission is if annexure A is quashed, consider it in a proper perspective.
I submit, my lord.
Yes.
The issue is not with respect to completion report, completion certificate. The issue is the liability which would be attached with respect to the completion certificate. Because according to them, they are liable only from the date of completion, now the actual date of completion, which according to them is 2011. Lord, according to the corporation, it is 2008. And so therefore, the liability which.
So if according to it is 2008, what is the basis of that?
Lord, the basis is that may I request the Lordship to kindly come to page number 20. Lord.
Yes. What is the basis on a legal basis? Not your wanting to get some money and
16th line, ನಗರ ಯೋಜನೆ ಮಧ್ಯದಲ್ಲಿ ನಗರ ಯೋಜನಾ ಜಂಟಿ ನಿರ್ದೇಶಕರು ತಮ್ಮ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 1/1/2014 ಮೆಸರ್ಸ್ ಬಿಎಂ ಹ್ಯಾಬಿಟೇಟ್ಸ್ ಅವರಿಗೆ ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡಿರುವ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನೀಡಿರುವ ಮಾಹಿತಿಯು ಸರಿಯಾಗಿರುತ್ತದೆ. ಇದನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಬರುವುದಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದೆ ಎಂದು ಬರಹ ನೀಡಿರುತ್ತಾರೆ. ನಂತರ ಸೋ ಅಂಡ್ ಸೋ ಇವರಿಗೆ ಮತ್ತೊಂದು ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಬರೆದು ಅದರಲ್ಲಿ 10ನೇ ಅಂಶದಲ್ಲಿ ದಿನಾಂಕ 25/4/2011 ಸದರಿ ಕಟ್ಟಡಕ್ಕೆ ಕಟ್ಟಡದ ಪೂರ್ಣಗೊಂಡ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನೀಡಿದ್ದು ಅದರಂತೆ ದಿನಾಂಕ 17/1/2008 ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡಿರುವುದಾಗಿ ದಾಖಲಿಸಲಾಗಿದೆ ಎಂದು ಸಹ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ಬಗ್ಗೆ ದಿನಾಂಕ 8/7/2010 ಒಂದು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಲು ಕೋರಿರುತ್ತಾರೆ. ಹಾಗೂ ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ದಿನಾಂಕ 8/7/2010 ಪರಿಶೀಲಿಸಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ವಾಣಿಜ್ಯ ಕಟ್ಟಡ ಸರಿಯಾಗಿ ನಿರ್ಮಿಸಿರುವ ಬಗ್ಗೆ ನಗರ ಯೋಜನಾ ಸದಸ್ಯರು, ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಹಾಗೂ ಅಧೀಕ್ಷಕ ಅಭಿಯಂತರರು ಇವರು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ದಿನಾಂಕ 26/7/2011 ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ರು. ಅದರಲ್ಲಿ ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ವರದಿ ಸರಿಯಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸುತ್ತಾರೆ. It so happens, my lord, they would have finished construction, my lord, they would have applied.
Was it occupied before that date? Otherwise, what we are asking you, did they rent it out? Did they get any income? Did they use it for their own benefit?
No, that would not know, because
unless you prove that,
would
you cannot backdate it to 2008.
May I read 310 of
Yes,
ANCR.
please read. Please
After
read.
the construction of the building, my lord, within 1 month after the construction of the building, they have to apply for completion certificate. They have applied in 2010.
Yes.
And we have inspected the building. And we have come to a conclusion that it was completed in all respects as on 2008 itself.
How do you say that?
So that is the report. That is the report of.
How do you say it was done in 2008?
Town planning department.
The report, but how do you say that?
Lord, the building was constructed. They have applied it. May I read further, my lord?
Even otherwise, from 2008, it was not occupied.
Occupied, my lord, with respect.
It was not used.
It is assigned because, my lord, our stand
If it
is
is
that
not
it
used,
was,
only land tax.
my lord, our stand is that it was completed with all in all respects as on 2008, and they have applied late because further than because the impugned order. ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಲು ಕೋರಿರುತ್ತಾರೆ. ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ದಿನಾಂಕ 8/7/2010 ಪರಿಶೀಲಿಸಬಹುದಾಗಿದೆ ಎಂದು ತಿಳಿಸುತ್ತಾರೆ. ಸದರಿ ವಾಣಿಜ್ಯ ಕಟ್ಟಡ ಸರಿಯಾಗಿ ನಿರ್ಮಿಸಿರುವ ಬಗ್ಗೆ ನಗರ ಯೋಜನಾ ಸದಸ್ಯರು, ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಹಾಗೂ ಅಧೀಕ್ಷಕ ಅಭಿಯಂತರು ನರ್ಮಿಯವರು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ದಿನಾಂಕ 26/7/2011 ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿತು. ಅದರಲ್ಲಿ ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ವರದಿ ಸರಿಯಾಗಿರುತ್ತೆ ತಿಳಿಸಿದೆ. ಮುಂದುವರೆದು ಬಿಎಂ ಹ್ಯಾಬಿಟೇಟ್ಸ್ ದಿನಾಂಕ 5/1/2008 ಜಂಟಿ ನಿರ್ದೇಶಕರು ನಗರ ಯೋಜನಾ ಶಾಖೆಯವರಿಗೆ ಪತ್ರವನ್ನು ಬರೆದು ಕಟ್ಟಡ ರಹದಾರಿಯನ್ನು ಮುಂದುವರಿಸಿಕೊಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. Petitioner here. ಆದರೆ ಸದರಿ ಪತ್ರವು ಈ ಕಚೇರಿಗೆ 28/2/2009 ರಂದು ತಲುಪಿರುತ್ತದೆ ಎಂದು ನಗರ ಯೋಜನಾಧಿಕಾರಿಯವರು ದಿನಾಂಕ 4/1/2018 ರಂದು ಬರೆದಿರುವ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಮಾಲೀಕರು ಸಲ್ಲಿಸಿರುವ ಮನವಿಯಲ್ಲಿ 1 ವರ್ಷದ ಹಿಂದಿನ ದಿನಾಂಕವನ್ನು ಅಂದರೆ 5/1/2008 ಎಂದು ನಮೂದಿಸಿ ಮನವಿ ಸಲ್ಲಿಸುವುದರ ಸಮಂಜಸವಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ರಹದಾರಿ ಮುಕ್ತಾಯಗೊಂಡ ನಂತರ ರಹದಾರಿ ನವೀಕರಣ ಕೋರಿ ಮನವಿಯನ್ನು ಮಲ್ಟಿಪ್ಲೆಕ್ಸ್ ನಿರ್ಮಾಣದ ಸಂಬಂಧ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರಿಂದ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ ಪಡೆಯುವವರೆಗೆ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ನೋಟಿಸ್ ಅನ್ನು ಮಾಲೀಕರಿಗೆ ನೀಡಲಾಗಿದೆ. ಸದರಿ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರದ ಅವಧಿಯನ್ನು 1 ವರ್ಷದ ಅವಧಿಗೆ ದಿನಾಂಕ 1/2/2010 ಮೂಲಕ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ವಿಸ್ತರಿಸುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾಲೀಕರು ರಹದಾರಿಯನ್ನು ನವೀಕರಿಸುವ ಬಗ್ಗೆ ಕ್ರಮ ಕೈಗೊಳ್ಳದೇ ಇರುವುದರಿಂದ ವಿಳಂಬ ಮಾಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ.
Extension of plan sanction because deputy commissioner
That
did
is
not
with
issue
respect to
NOC.
fire and other this thing, my lord, they have applied.
You cannot do like
Now,
that.
my lord, the question is regarding tax, my lord, not with respect to completion certificate. No, my lord.
You as an authority have to come out fair.
Lord,
It's not like this.
As to when the building was constructed.
We'll deal with
completion.
that.
So therefore, my submission may be recorded. So therefore, it is a disputed question of fact. And my lord, moreover, my lord, may I submit, my lord, and as per section 11(3) of the Karnataka Municipal Corporation Act, there is an appeal provided. My lord, ultimately, my lord, annexure P is challenged. No matter how the thing is worded, my lord, reliefs are worded. In essence, my lord, annexure P is challenged, which is a Tiluvalike notice, and a demand notice was already issued. Thereafter, my lord, this notice came to be issued, and this was challenged before this honorable court on the ground that his representation was not considered. And thereafter, my lord, we did consider his representation and passed annexure A. Now, annexure A is challenged, my lord.
You see now well you have considered it.
My lord, annexure, kindly come to annexure A, my lord. And it was considered properly, my lord.
Yes.
Considered properly. May I request the lordship to come to.
In one para ಇದೆ ಓದ್ಬಿಡಿ. ಎಲ್ಲ ಓದಿ ಆಯ್ತು ಲಾಸ್ಟ್ ಪ್ಯಾರ ಒಂದು ಓದು.
ಆದರೆ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕಟ್ಟಡದ ರಹದಾರಿಯನ್ನು ಮುಂದುವರೆಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಈ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದ ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡುವ ಪ್ರಶ್ನೆಯೇ ಉದ್ಭವಿಸುವುದಿಲ್ಲ ಎಂದು ಸಹ ತಿಳಿಸಿರುತ್ತಾರೆ. ಹಾಗೂ ಕೆಎಂಸಿ ಕಾಯ್ದೆ ಅನ್ವಯ ಕಂದಾಯ ನಿಗದಿಪಡಿಸುವ ಬಗ್ಗೆ ಉಪ ಆಯುಕ್ತರು ಕಂದಾಯ ಇವರ ಹಂತದಲ್ಲೇ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ಸೂಕ್ತವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಕೂಲಂಕುಷವಾಗಿ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಮೇಲಿನ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದ ಈ ಕೆಳಕಂಡ ಆದೇಶ ನೀಡಿದೆ. ಅರ್ಜಿದಾರರು ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಕೋರಿರುವಂತೆ ಅವರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಲಾಗಿದೆ ಹಾಗೂ ದಿನಾಂಕ 2/5/2015 ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ಸೊ ಕಂದಾಯವನ್ನು ದಿನಾಂಕ 17/1/2008 ರಿಂದ ನಿಗದಿಪಡಿಸಿ ಪಾತ್ರ ಸೂಚಿಸಿರುವುದು ಸಮಂಜಸವಾಗಿದೆ ಎಂದು ಆದೇಶಿಸಿದೆ. Now, with respect to construction, whether it was constructed in whether the construction was completed in 2008 or 2011 is the question, which is a disputed question of fact. And now we have conducted.
What have you placed on record that it was completed on that day?
I place records. I'll definitely place the records as to on what basis they have come to such
Monday,
a
place.
Monday,
Tuesday,
Wednesday. On what basis they have come to such conclusion?
It is not occupied. You cannot do this.
Great.
We'll record ಮಾಡಿ your submission. We'll record your submission and deal with it.
When it was completed, it is a question of fact, my lord, and also, my lord, under
It is not a question of fact when you said that they themselves asked for renewal of the plans.
So renewal, they have asked the deputy commissioner, my lord, with respect to fire and other aspects.
Yes,
Not
so
this.
that was not given.
My lord, that was not given, but this letter, my lord.
So could they ಸ್ಥಗಿತಪಡಿಸಿದ್ದಾರೆ ಅಂತಾನು ಹೇಳಿದೀರಾ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇನ್ನೇನ್ ಬೇಕಪ್ಪ
after like 1 year, my lord, after a period of 1 year.
Yes, Mr. Hello. No need we are disposing.
My lord, I'll place records.
Not
I'll place records because, my lord, one opportunity may be granted because on what basis they have come to a conclusion. If there is no such basis, my lord, on Wednesday.
No problem. We'll have it on Wednesday. Looks like you want cost to be imposed. We'll impose quite a bit of cost.
Not like that.
ನಿಮ್ದು ಟ್ಯಾಕ್ಸ್ ಎಷ್ಟಪ್ಪ ಒಂದು ವರ್ಷಕ್ಕೆ 8 ಲಕ್ಷ 28 lakhs. Cost of 28 lakhs is a good amount. Round figure 25. We'll see.
My lord, your lordship,
you place it.
Your lordship may kindly consider this, my lord. There is an appeal provided under section 113.
You place that document, then we'll deal.
Appeal under the district judge. District judge, there is an appeal provided.
They have directed us not to that.
Same one.
Out of vengeance, my lord, my instructions. My lord, it could be disposed. My submissions may be recorded and it could be disposed.
Now you place the records.
It could be disposed, my lord. My lord, it could be disposed, my lord, my submissions may be recorded and it could be.
There's no record that you have for it. But you
Really?
should not arise in city.
20,000 and order, where we go to issue commencement certificate in the month of May 2007.
Demand notice was issued section 113 ಕೆಳಗಡೆ there is an appeal provided.
In 6 months, I have completed 2,20,000 square feet of structure and secondary. Could you photograph?
Petitioner is before this court seeking for the following reliefs. The petitioner is before this court seeking for the following, is aggrieved by the demand made by the respondent corporation for payment of property tax calculated from (17/1/2008) on the ground that the building was completed on that date, even though the occupancy certificate came to be issued on 25/4 alert. 26/7 is the inspection report. 25/4/2011.
Yes.
Krishna seems to be the owner of the property bearing number 2270/D, D-22/E, 2270/A1, situated Vinoba Nagar Road, Jayalakshmipuram, Mysore. The petitioner, having applied for sanction of plan, that is sanction was issued on 18/1/2005. Commencement certificate in terms of the applicable building laws, bylaws came to be issued on 3/5/2007. Thereafter, the petitioner commenced the construction and submitted an application on 2/12/2010 for issuance of the occupancy certificate, which came to be issued on 28/4/2011. Subsequent thereto, the respondent corporation by order dated 2/5/2015 called upon the petitioner to make payment of property tax from 17/1/2008, which came to be challenged by the petitioner before this court in WP number
21/481 of
page
2000.
number
21/481.
21/481 of 2015.
481 of 2015. And this court by its order dated 21st May 2015 permitted the petitioner to furnish its explanation to said demand, which was directed to be considered by the corporation, necessary orders to be passed thereon. And until then, the respondents were restrained from taking any further steps. After hearing the petitioner and considering the documents furnished by the petitioner, the impugned order dated 15/2/2018 has been passed, wherein the very same order dated 17/1/2008 has been confirmed, and the demand made for payment of property tax from 17/1/2008, which is under challenge in this present proceedings. 3. Rajshekar S. Learned Counsel for the petitioner would submit that the petitioner completed the construction only in December 2010 on account of July 2010 on account of the NOC to be issued by the Deputy Commissioner for running a multiplex, as also the fire clearance having been delayed. And it's only thereafter that the application for grant of occupancy certificate was made on 2/12/2010.
First application,
5/7. What did you submit on 5/7?
5/7.
5/7/2010. On 2/12, what did you say?
Second,
Why second application?
they are not considered.
So the same was not considered. Another application was submitted on 2/12/2010. Thereafter, inspection was carried out and occupancy certificate was issued on 28/4/2011. This delay on part of the respondents in considering the application cannot be mulched on the petitioner. The petitioner has not made use of the building for its own purposes or for rental. The building being used only after the occupancy certificate has been issued, the property tax would be required to be calculated from the date of the occupancy certificate and not prior there. Shri Pallava R. Learned Counsel for respond number 1 to 4 would submit that the date of completion of the building is wrongly been mentioned by the petitioners, inasmuch as the building is deemed to have been completed as on 17/1/2008 on account of the plan sanction being valid up to that date. That is to say, and it is on that basis it submits that the building ought to have been constructed by 17/1/2008. And therefore, the property tax is liable to be paid from the date of the deemed construction of the building. The delay by the Deputy Commissioner in issuing NOCs and or by the fire clearance, fire services in issuing NOC is not to the account of the corporation, and their delay cannot deprive the corporation of their valid and due tax. Ashtana, anything else?
So there's an appeal provided under section 113.
Lastly, he submits that there is an appeal provision under section 113 of the Karnataka Municipal Corporation Act, which can be resorted to by the petitioner instead of this court considering the above matter. On all the above grounds, he submits that the above petition is required to be dismissed. Third, Shri Rajshekar S. Learned Counsel for the petitioner, Shri Pallava R. Learned Counsel for respond number 1 and 2, 1 to 4, various papers. The short question that would arise for consideration is as to from when the property tax is required to be paid on the property, and could there be a deeming fiction brought into consideration taken into consideration by the corporation to contend that the building was ready for levy of property tax? Question. It is not in dispute that the plan was sanctioned on 18/1/2005. Commencement certificate was issued on 3/5/2007. 18/1/2006. 2005 and that. 18/1/2006. Commencement certificate was issued on 3/5/2007. And that the total constructed area is 220,860 square feet. If the submission of Sri Pallava is to be accepted, then it would mean that between 3/5/2007 and 17/1/2008, that is within a period of 8 months, less than 8 months, 220,000 square feet of construction area of construction was to be put up for how many floors? For 4 floors. Though the plan was valid up to 17/1/2008, in my considered opinion, the corporation cannot seek to bring in a deeming fiction to contend that since the plan expires on a particular date, the construction is deemed to have been completed by that date without verifying the actual facts and without necessary documentation being placed on record that the building was constructed and was put to use. The very impugned order takes note of the fact that The NOC was issued on 1/2/2010. Until such NOC was issued, the petitioner could also not have made use of the property for any of the purposes, let alone as a multiplex or a mall. After after the NOC was received on 1/2/2010, and after finishing works, an application was made on 5/7/2010. This application did not yield any results, inasmuch as the corporation did not carry out an inspection of the property to ascertain the construction which has been put up and whether the said construction is in accordance with the plan sanction, requiring the petitioner to submit one more application on 2/12/2010, and it's only on 28/4/2021 that the occupancy certificate was issued. 25, how is it 28/4? 28, your date was on 25/4/2020, 2011. There's a delay thus there is a considerable delay on part of the corporation also in inspecting the property and issuing a occupancy certificate. This delay also cannot be made use of by the corporation to shift the date of completion of construction and or occupancy. There is no document placed on record that the petitioners have occupied and or used the property prior to the occupancy certificate. The use of the property having commenced only post the occupancy certificate having been issued. The property being used for the benefit of the petitioner only thereafter. It is only then that the incidence of property tax, only then that the building would become exigible for tax, since the incidence of tax or property tax is on the building once completed. And until then, the incidence of property tax would only be on the land, open land, and not on constructed building. In that view of the matter, I have the considered opinion that no deemed fiction can be made use of by the corporation to consider that, to insist that the building was ready by the date on which the plan expired. If at all the construction had not been completed by the date on which the plan expired, or that the building was constructed thereafter, it would have been available for the corporation to take necessary action at that point of time, which cannot also now be taken due to lapse of time. That's looked at from any angle. The actions on part of the corporation are completely unjustified. This court refrains from using any other stronger words in relation thereto. Hence, I pass the following order. Writ petition is allowed. The circular is issued. The order dated 15/2/2018. Such and so and so. The respondent number 1 at annexure A is quashed. Respondent number 1 is directed to receive property tax commencing from 25/4/2011.
Even according to them, from 2010 it is.
Complete occupancy or we use. Is it your case that without occupancy certificate people can use?
Even according to them, the building.
New Year, but even
according.
then there won't be any value for your corporation.
Even according to them, 2010 will complete.
It's complete, but when was it used?
My lord, tenants may come later, my lord, and it could
Tax is only if I use the property, not without use. Vacancy remission.
My lord, it's tenants, my lord, occupy later or they occupy. It's a mall, my lord.
From 25/4/2011. Other matters won't reach. Eight quarter, we'll have to consider and pass on.
Serial number 86, my lord. 86 is covered matter, my lord, on short date.
Ella date for the short date, tell you, Mr. Graduate, because you are moving so many memos that around 80 matters can be handled. More than that, it won't reach. It will be uploaded.
Serial number 96, my lord. I pray that engine model not to continue. I am okay. How he is going to engine model, he is putting up a temple there. The land earmarked for under asking temple.
Are you putting up a temple?
Yes.
It's Ashraya scheme site. Are you putting up a temple?
Yes.
Only in respect of petition number 15 he trust in
It may be. How did the allotment happen to a trust in Ashraya scheme?
Idili prayer on the Hakpata Guru Hakitu, and the Uru Ketu, the trust was created in July.
You cannot construct anything, any temple or the like on a residential site. This is for depressed classes.
Yes, please.
You cannot have a temple there and conduct business.
What is created on July 2023. October he filed the petition. Because of the interim he continues to be constructed.
But trust, agli, this is Ashraya scheme. You cannot have any right on an Ashraya scheme property. You just cannot have a right. It is only if you satisfy that low income can you give. ನಿಮ್ಮ ಮಟ್ಟಕ್ಕೆ ಬಹಳ ಇನ್ಕಮ್ ಇದೆ. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಇನ್ನೊಂದು 100 ಎಕರೆ ಎಲ್ಲರೂ ತಗೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಸೈಟ್ ಮಾಡ್ಕೊಡಿ. Small ಅಲ್ಲ. You cannot do this. 98. 98.
96.
Yes, not
96. 96. It is made clear that the 15th petitioner shall not carry out any construction work on the subject property till the next date of hearing. Interim order insofar as petition number 1 to 14 are concerned is extended till next date.
Area number
Next. Yes. Listed Gunjal, every day there are 80 matters already listed. None of these will reach before vacation. None of them will reach. Every day we have, in fact, on Wednesday we have 95 matters. Because it's instant. New matters will be another 10-15. So it will be 110 matters. It won't reach. We are telling you it won't reach. You are not listening.
on a serial number 93.
All interim orders will be extended.
You're on serial 93 below. 93, 93.1 and 2. All three are in challenging the same order. Let it be having the same date for all the three people.
93?
93, 1 and 2. 93, 1, 93, 2.
It will come on the same day.
And moreover, 93, 2, my lord, there is no interim order challenging the same order. In two cases, there is an interim order.
It will all come on the same day.
93 and 93, what? There is an order, my lord. 66.
Everything is covered. We'll have to uncover it.
Photo officer. ಆಫ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತಾರೆ ಅವರು ಆಫ್ ಮಾಡ್ಕೊತಾರೆ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಇರ್ತಾರೆ Court officer. Court officer. ನೀವು ಹೇಳ್ತೀರಾ ನೋಡಿದ್ರೆ ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ ಇದ್ರದ್ದು ಏನಾದ್ರು ಎಫೆಕ್ಟ್ ಇದೆಯಾ ಇದೇನಾಗಿದೆ ಇದು ಇದೆ ಲಿಂಗರಾಜ್
ಗಿರೀಶ್ ಅವರ ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್ ಇದೆ, ಏನು ಮಾತಾಡ್ಬೇಡಿ.
ಐದು ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಸರ್, ಬರ್ತಾರೆ. ಇಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. 5 minutes ವೇಟ್ ಮಾಡಿ.
ಅವನಿಗೆ ಫೋನ್ ಮಾಡ್ರಿ, ಎಂತ ಆಯ್ತೇನಾ ಶಿವಕುಮಾರ್ ಇದೆಯಾ? ₹5,000 ದಂಡ ಹಾಕ್ಸ್ಕೊಂಬನ.
ಮೇಡಮ್ ಮೇಲೆ ಹೋದ ನಿಮ್ಮ ಮಗ
ಮೇಡಮ್ ತರ ಕಾಣ್ತಾನೆ ಅಂತೀನಿ. ಇಲ್ಲ ಎರಡು ಇಬ್ರದ್ದು ಹೋಲಿಸ್ತೀನಿ.
ತಾಯಿ ಲಕ್ಷಣ ಬಂದ್ರೆ ತುಂಬಾ ಅದೃಷ್ಟ ಅಂತ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ 86 ಆನ್ ಶಾರ್ಟ್ ಡೇಟ್.
ಅವ್ರು ಲಾಯರ್ ಹತ್ರ ಮಾತಾಡ್ತವ್ರೆ, ಬರ್ತಾರೆ ಸರ್, ಒಂದು 5 ನಿಮಿಷ.
ಗಿರೀಶ್ ನಮ್ಗೊಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ಸಿ. ಗಿರೀಶ್ ಬೆಳೆದಾರೆ.
5 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ. ಇಲ್ಲೇ ಅಟೆಂಡ್ ಮಾಡು. ಅರ್ಜೆಂಟ್ ಇದು ಇವಾಗ ಅರ್ಜೆಂಟ್ ಆಗಿತ್ತು ಮೇಡಮ್. ಏನು ಅರ್ಜೆಂಟ್ ಕೊಡ್ಬೇಕು.
ಸರ್ ಇವಾಗ ಹೇಳಿ ಸರ್.
84 and 91 ಮೇಡಮ್.
ಸರ್
ಒಂದೇ ಡೇಟ್ ಕೊಡಿ. 84 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್.
91 ಇನ್ನೊಂದು 91 ಸೇಮ್ ಡೇಟ್ ಇರ್ಲಾ ಸರ್?
ಸೇಮ್ ಡೇಟ್ ಇರ್ಲಿ ಮೇಡಮ್.
ಓಕೆ ಸರ್.
ಮೇಡಮ್
6th ಡಿಸೆಂಬರ್ ಎರಡೂನು.
ಎರಡು. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಮೇಡಮ್.
94 ಯಾವತ್ ಬೇಕು ಸರ್ ಅದು?
ಡೇಟ್ ಎನಿ ಡೇಟ್ ಮೇಡಮ್. ಅದು
ಸರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಬೇಕು.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಪ್ಲೀಸ್ ಮಾ.
4th January.
86 ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಸರ್
86 ಸರ್ 86 20 ಡಿಸೆಂಬರ್.
ಮೇಡಮ್ ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಡೇಟ್ ಇನ್ನು.
ಅದೇ ಅಷ್ಟೇ ರೀಚ್ ಆಗಲ್ಲ.
6th ಏನಾದ್ರು ಕೊಡಿ ಮೇಡಮ್.
ಕಾಯ್ಬೇಕು, ಹಿಂಗೆ ಕಾಯ್ಬೇಕು. 23 ಮ್ಯಾಟರ್ ಅಲ್ವಾ ನಿಮ್ದು?
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಮೇಡಮ್.
ಕಾಯ್ತೀರಾ?
ಕಾಯ್ತೀನಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಡಿಸೆಂಬರ್ 19th ಏನಾದ್ರು.
94 ಸರ್ ಅದು ಬೆಳಗ್ಗೆನೆ ಅಡ್ಜನ್ ಆಗೋಗಿದೆ 12th ಡಿಸೆಂಬರ್ಗೆ.
ಪ್ಲೀಸ್ ಓಕೆ
ಮೇಡಮ್ 6th ಕೊಟ್ರಾ 86?
ಸರ್ 6th ಡಿಸೆಂಬರ್ ಮಾಡಿದೀನಿ, ಗೊತ್ತಿಲ್ಲ, ನೀವು ಕಾಯ್ಬೇಕು ಹಿಂಗೆ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು. ಏನಮ್ಮ
ಸರ್ ಕೇಶವಮೂರ್ತಿ ಸರ್ ನಿಮ್ದೇನ್ ಬೇಕು ಸರ್? ಪ್ರಕಾಶ್
84 91 6th ಡಿಸೆಂಬರ್ ಅಲ್ಲ ಮೇಡಮ್?
ಆಯ್ತು ಅಲ್ಲ ಇನ್ನು ಲೈನ್ ಅಲ್ಲೇ ಇದ್ರಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದೆ. ಕೇಶವಮೂರ್ತಿ ಸರ್
64 ಮೇಡಮ್ ಅವರ
ಹೇಳಿ ಸರ್ ಯಾವತ್ ಬೇಕು?
ಹಾಕಿ ಮೇಡಮ್ ಒಂದ್ 2-3 ವಾರ ಬಿಟ್ಟು.
2 ವಾರ ಬಿಟ್ಟು 20 ಡಿಸೆಂಬರ್.
ಆಯ್ತು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಯಾರು ಇವ್ರೊಬ್ರು ಇದಾರೆ, ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ಸರ್. ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕೇಳ್ತೀನಿ ರೀ ಏನು ಅಂತ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 94
ಯಾವತ್ ಬೇಕು?
ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲಿ
4th January.
ಜಾನ್ವರಿನಾ ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಮೇಡಮ್?
ಅವ್ರ ಅದರ್ ಸೈಡ್ ಅವರು ಈ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ. 4th January.
ಯಾವ ಜಾನ್ವರಿಯಾ?
4th January.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅದರಲ್ಲಿ.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಪ್ಲೀಸ್ ಓಕೆ.